not in my desire. If the board desire, the board can do that. With or without cost.
Yes, with or without cause.
I'm just thinking.
That's all.
I wasn't feeling behaved. Go ahead.
No, you can say whatever you want, you can do whatever you want, go right ahead. Fellow Vice President, can I? Thank you, sir. So, I'll say this and I'll shut it down. It is up to the board, their decision. It's not up to Gilbert or McNeil. It's up to this board that's here now, this seated. We have a quorum. If the board votes that way, the only thing that I am saying on the record is that the trustee is not going to get my vote. That's the only thing that I'm saying. And I want that to be very clear. Thank you.
Okay. I have a comment. Does anyone else have a comment? Okay, so I had spoke with MASB earlier this morning, and one of the things that was pointed out from this reading that Pastor Gilbert just gave us is that we shall fill the position. So it makes it mandatory. The problem, though, is number one, it doesn't give a time limit. It doesn't say within a week, 30 days. It's void of that language. He also indicated, well, that's just, I guess, another subject. I know when the vote was taken to remove our now current president, who took over because the president was removed, indicated the desire for the position, thinking one could serve both in both positions. Correct me if I'm wrong. So I don't want to go, I don't want to vote this, me personally, this evening, though if it, for the position, because one has already expressed a desire for the position. And go ahead.
So if I hear you correctly, you're saying that you're holding the position of treasurer open so that the president of the board may also serve as treasurer?
No, she may, I don't know her thinking, but she may wish to step aside from that position and serve as treasurer. And I'm trying to, let me say, be somewhat fair to everyone. But, go ahead. I'll give you the floor.
So, we have an open meeting. It was posted, announced. It's a committee meeting of the whole. She's able to be here and is not. We have the business of the district at hand, and it is imperative that we have a treasurer. We have some invoices or some bills that are being paid without invoices that, in my opinion, are improper and unethical. And we really need is, according to our bylaws, that we need the treasurer to be signing and approving these bills, invoices, even the payroll. We have a fiscal duty and a responsibility to the district to act on that immediately. Just because a single board member declines to be present at a meeting is no reason to shirk our duties. This is about the children. This is about our district. This isn't about an individual who perhaps may wish to hold an individual position. At this point, we've seen the commitments and the priority. The president is not here. We are. We have to move forward as a district. It is negligent to not have a treasurer. And I would even go so far as to say it was negligent to remove me as treasurer, given the questions that I was asking and the duties that I was fulfilling. I was doing nothing else besides asking some hard questions about certain individuals getting paid and requesting the proper documentation, the proper invoices. And it's my fear that if this is not taken care of tonight, that we are going to be in violation of state statutes, possibly state laws, at worst, and if not the state laws and statutes, then certainly there are conflicts of interest and ethical and moral violations occurring because of some of these bills that we are paying. And I cannot, as a publicly elected, as one of the few publicly elected people on this board, to subject our community to that kind of fiscal mismanagement. And so I am pleading with the board to please allow me to do what I was elected to do, because I am not acting in any personal interest. I'm not acting with bias or as an individual. I'm following the bylaws, I'm following policies and procedures, and I feel that I've been unfairly punished and persecuted for merely asking questions that certain parties of interest do not want asked. Thank you.
Okay. If I can, let me say add to that or mention this. So, in talking to Lansing, Attorney Lansing from MASB today, he indicated a couple of things. One is that we do not need to have a treasurer at our board meetings or at the committee of the whole meetings in order to have a meeting. He also...
Point of information, that is not the claim I was making. That is not, I don't think anyone's making that claim.
Okay, no, I'm just...
Okay, all right. Point of information, I was saying that it is our moral, ethical, and fiscal responsibility to have a treasurer because we are custodians and stewards of millions of dollars of the public's trust.
Absolutely.
Point of information.
Pastor Gilbert.
Thank you, Vice President Delmoni. I would ask my colleagues if they would oblige one another to let one another finish what they have to say. And then you can retort, rebuke, say what you have to say. But let each individual finish what they have to say. At least we can do that. We may not like one another.
Point of information.
But at least we can do that.
And what's your point?
Chairman, if you could remind, this is a point of information, you could remind our esteemed trustee that a point of information is merely pointing out information, which is what was happening. And if he could possibly refrain from interjecting personal anecdotes.
Point of order.
What's your point?
My point is that, trustee, you opened this up. You started talking about how you're a victim. You did this. You opened that up.
Point of order, he's not addressing.
No, you did.
Point of order,
So
Chairman.
if I'm out of order, you're out of order. Because you're the one who opened it up.
Pastor Gilbert, can you hang up on that?
Point of order, the trustee is not addressing the point of order, he's out of order.
So we're going to...
It's not for you to decide, it's for the chairman to decide.
Point of order,
not you.
Point of order, please.
What's your point of order?
It's only 4 or 5 of us here. And we're really kind of like ignoring rules, Robert rules, the chairman. I would like to say this, unless there's a hidden agenda, why we're so adamant about having on certain people, because we know what the role of the treasurer is to do. Is to look, dissect, ask questions, and approve. Unfortunately, this particular treasure here is just not a rubber stamp, but as we have been to the oath, to the public, set an example of leadership. What does leadership look like? Leadership is not about personal feelings. Leadership is about doing the board's business. And we all probably got emails, full emails on our calls, how we conduct ourselves. At this point, we can move on. The chairperson has a moral responsibility, every one of us. Why is this such a hidden agenda not to have a treasurer and to move forward? It's just simple as that. The treasurer doesn't have any power. The president doesn't have any power. We all went to their training in Muskegon.
Point of information.
I'm still speaking.
Point of information. It's a privilege. Motion.
Yes, it is.
It's a privilege. Do you have proof that people have hidden agendas? Do you have? Can you prove that? I'm asking you. I'm making a quick inquiry. Can you prove that?
Point of information. If our esteemed trustee would like, thank you. If our esteemed trustee would like proof, I do have a text that he did mistakenly send to the superintendent and myself, in which he discloses a nefarious opinion about the rest of the board members, and esteem for one particular board member in particular.
Point of information. Point of information. If we're here to take care of district business, what's that got to do with the district business?
You asked the question.
I'm asking. Whoever put that out, they did that to destroy me, to hurt me.
Point of information. I have a text.
That's right.
By Pastor Gilbert.
But that's not the district business. It wasn't district business.
Yes, it was district.
No, it wasn't. It was mistakenly sent. It was mistakenly sent to a group by mistake. You called me and told me that it was a mistake. Is that correct?
I pointed out.
No, I just asked you a question.
You should not violate.
Point of order. Point of order. Point of order. Point of order. We're being distracted from the most important thing of this agenda. That we come together as a, put away your difference, and we understand what one board member stands.
Point of information. Point of information.
What is your point?
First of all, are you the chairperson of this government meeting?
Point of order. Point of order. I ain't making a statement.
Chris, the chairperson.
Point of order.
Is Brother Devon Maloney the chairperson, or are you the chairperson?
Point of order.
That's what I want
What
to
is
know.
your point, but we're going to bring to a close?
Thank you. Vice President Chris Delmar, I am even in my opinion, or need would I ever disrespect the chair that you're sitting in. I respect the chair that you're sitting in. I was making a statement and some concern about we having a treasurer and not being influenced by any outside forces. I was just trying to make a statement, and we could move forward with a treasurer. That's all I was saying. And that treasurer can be any of us that are not already chairing a seat. The vice president has a seat, the president has a seat, the one person is the chairperson, the other person is the chairperson here. Only thing I'm requesting, there's nothing illegal about it. It's making the chairperson bringing back a treasurer. So we can do that. But I don't think that it'll be finished. I just don't think we're gonna move forward as long as 6 of us divide. Together we can do this, but divided, we require it to be always divided, all the way through election. And that is not the desire of the community or the people. That's all I have to say. And thank you very much.
So, as I had before we had all those points and everything, the attorney from MASD, which I didn't know, actually said that we could get a treasurer from outside the board. That person would serve not as a board member, they would have no, no vote or anything like that. And I just throw that out there as a different option because I don't know that tonight we sent some kind of divide. And
Point of information.
go ahead.
We are speaking in third party. We say, somebody said this, one person said that when I was speaking with MASB as well, is what, we can go by what our board policy says. They can advise us on different things, but the board has the power to act as a board as related to our policy. And our policy does not say that we don't get it. Our policy doesn't. Has suggested certain things, which they do. But as our policy stated, and it always been that for years, that we have them 4 officers in place. Once again, I would like to see that not as a board member, so we can move forward and try as hard as possible, because I have no problem putting away my opinion, but I am going to operate on these policies and bylaws. Thank you.
Board member, Madam
Thank you, Mr. Chairman. I would like to, I know the hard work that you've done in the community off the board in city council. And as a city who's in year 8 of the water crisis, which was precipitated by financial emergency manager takeover, I would really urge you strongly to reconsider the possibility of bringing in someone from the outside, which is much akin to having a financial emergency manager, which as residents and citizens of Flint, we are vehemently and strongly against. We are able to self-govern, and we should self-govern. And the whole fight and journey about this board is about autonomy, self-determination, and self-governance. So to me, deferring to an outside person to run the business of the board would be admitting defeat, setting ourselves up for state takeover, for creating ammunition to show that we cannot be self-governing, and there really is no reason why we cannot fulfill that duty and responsibility as a board. We are perfectly capable of it. And as I stated, whether I was removed with cause or without cause, I did nothing except ask very difficult questions in the best interest of the district. And so I think maybe the rest of the board should ask themselves, what questions was I asking? And who wanted the answers and who didn't want the answers? And what I was doing during the meeting in which it was sabotaged with an assault. What information was I trying to get out to the public? What questions was I asking? And what was I trying to shed light on that somebody so desperately wants to keep in the shadows and in the darkness? So again, I urge my fellow board members to please allow me to do what the public elected me to do, and to keep our district and our schools open and public, keep our public schools public, and keep us under self-governance and self-rule.
So if I may, I was just throwing that out as another scenario. I wouldn't say I was necessarily backing it. I mean, the person who comes to mind to fill that position from the outside would be, she works with us quite often, and from Clyde. She was part of the district at one time, think blondish color hair, white female.
Here is the costume.
Yes. But, I mean, that's what comes to mind. There could be others. I'm not saying to do that, just like I'm not saying to, we could vote in an assistant secretary treasurer and have them fill in until we can agree on a treasurer. It's just something that's available to the board. Go ahead.
Well, I thank you. Well, I certainly agree with you that there are several things that we could do. I'm appealing to your sense of ethics and of doing the right thing. We can bring in an outsider. We can ask for the state to come in and take us over. We can defer to GISD and be absorbed into their school district. We can turn ourselves over to our community partners to let them take our extra money and spend it how they wish instead of how we wish. There's a lot of things that we can do. But what should we be doing, Mr. Chairman? What should we be doing? And I'm saying we should elect a treasurer. And I am advocating for myself because of the job. You look at my track record, it speaks for itself. If you look at the opposition against me, that too speaks for itself. And I'm just urging you to do the right thing and move forward.
Does anyone else want to speak on this? I don't even think we have a motion on the floor at this point.
If we bring someone else from the outside, would there be a cost for that?
I'm sure they would ask for compensation. I have no idea. What would that be?
Right. Well, we want to show that we have the competency to do, play the role of vice president, president, secretary, which I am treasurer. We don't want to show that we're incompetent, to do serve on this board. So I would recommend that we try to vote on a treasurer.
So, there is no motion. We can move on, or someone.
Yeah, there's a motion on the floor. I would like to make a motion that we vote for Laura McIntyre to treasurer.
Okay, so there's a motion that's been made to move or make Laura McIntyre our treasurer.
So you need a second.
Support.
It's been properly supported. Is there any discussion? I think we've kind of hit a lot of points already. I would just say for myself, I would like to see this done at the committee of the whole or the full board, which would be tomorrow.
Point of information,
Go ahead, which point?
this is a committee of the whole meeting right now.
Right. Governance, no.
Yes, so you're asking to wait for a committee of the whole meeting, and my point is that this is one.
Okay. Points well taken. I'll just say that I was referring to the committee of the whole, as opposed to as to opposed to a governance.
Point of order, respectfully, Mr. Chairman. This is a committee of the whole meeting. There's a distinction between the governance committee meeting. This is a governance committee meeting of the whole. There are two different types of meetings. So this is a committee meeting of the whole.
Okay.
So if you're waiting for a committee meeting of the whole, I'm not quite sure what your point is.
So committee of the whole or the full board, but
Point of information, Mr. Chairman, this is a
Well-
full board. This is a full board meeting. It meeting, according to the Open Meetings Act, it's been notified and published. This is the full board, or all the board members who choose to be here at a full board meeting. This is a committee meeting of the whole.
All right. Pastor Gilbert.
Thank you, Vice President Demaroni. It is a committee of the whole, and those that we know our responsibilities as board members and what have you. I'm with you. I think all the board members should be present so that can be the just and fair way to do it. It would not be wrong if we did vote for someone at this time. But I have the same position that you have. The president is not present, and that's not here or there. It's not illegal to take the vote. It's legal to take the vote. And so, if that has been the motion, and properly moved, properly second, we're in discussion. And I'm going to vote no. That'll be my position. That's just my own personal view. Has nothing to do with the type of job or whatever. That's just my personal disposition. That's it.
Board member McNeil.
Yes. I hear the discussion we're talking about having all board members here to make a vote. And we have made bigger decisions than this with 5 members at the board and 2 absent. And then would be like the superintendent and the assistant superintendent. And you all made a vote with 5. We have been making votes. This district has done a lot because for 2 or 3 months, only 5 of us, 4 or 5 of us. I can think that Trustee Gilbert might maybe one meeting, maybe not. But all 5 of us have always been here and made votes. And I don't regret votes that I made. We are individuals selected as a body to carry this district. The district saying that you can carry this district with 4 or more bodies. And that is what we're here to do, to put aside our different, trying to, strong arm each other. This is about the district. I don't have a check in my name, none of us gets checks in our name, but then the $30-some a week, a meeting. What is the problem in having the right person and just to be treasurer? There's nothing, in my opinion, wrong with it, but I'm ready to move on. I think that we should move on as a body, doing due diligence, and to do the right thing. I know we got a lot of people we're trying to satisfy, but let's satisfy the people that's put us in this seat, the voters, the children, and let the world see what leadership are. We're talking about bringing students on our board that we selected, and they need to see us following policy and doing the right thing.
Pastor Gilbert.
Thank you.
I think it should be concerning the district business only. That's what the treasurer responsibility should come. And my position is that they shouldn't come from the outside, not because they're going to get paid, because this district pays a lot of people from the outside. We got a lot of vendors that we should be paying. But the point is that it's just the vote has to be taken. Let's take the vote and let's see what happens. I'm just one board member. I have a right to vote the way that I feel, and I'm going to do that. But let's do it democratically. Let's do it right. And let's move on and take care of the rest of the agenda. And so that the business of the district can go forward. I don't care about who likes me, who don't like me, what they think. It's about the kids. It's about these teachers. It's about those parapros that was out there. And I think sometimes we get confused as to what we're here to do. So irregardless of how I feel, don't worry about my feelings. I'm a big boy. But the kids are the ones that need to have have things done right on their behalf. That's the only thing that I've got to say. Thank you.
Okay. Does anyone else have to yield?
Vice President Devereaux, I'll call for the question.
Okay, question has been called. Do a roll call for that. Pastor Gilbert?
No.
No one calling?
Oh, yes for the question, I'm sorry.
Okay. Board member Linda Bruce.
Can you repeat that again, please?
So, the question has been called for by Pastor Gilbert, and we're basically voting to cease debate
Okay,
on the motion, and then we'll go to the motion for a vote.
okay, yes.
Okay, Board member McIntyre,
Yes to call the question.
Board member McNeil,
Yes to call the question.
Board member McIntosh is not present, and we have one open seat. Board member myself, Chris Delmaroni, yes. And so now we're at the motion. I'm not sure who may have written it
I
down.
made a motion that Laura McIntyre be treasurer.
I'm sorry, that what?
I made the motion that Laura McIntyre for treasurer. And supported.
So, we've had our discussion, we'll do roll call. Board member Linda Bruce,
Yes,
board member McIntyre,
Yes.
board member McNeil,
Yes.
board member Gilbert,
No.
and board member, yes, and board member myself, Chris Delmaroni, no. So the vote is 3 yeses, 2 noes, 1 abstain, or 1 not here, and
1 absent.
1 open seat. So it fails. We can move on to community relations. I don't know who's taking her notes or not. I would like, if we can, bring this up tomorrow. No, to bring up this treasure assistant thing, to see who all has an interest, and we didn't even do that tonight. So we're at community relations chair. Board member McNeil.
Oh, that was just an open position, if somebody, I don't want it, so I don't know.
Okay, and you're saying it's open because I was the chair of it, and by becoming vice president, I can no longer sit on that. Okay. Yes, we need to fill that along with, as I'm looking at this handout here that was given to us this evening, there are many positions open on these standing committees. Some have no members. So we need to deal with that. We have one opening on, what is this, academics. There are no members on the community relations.
point of information, I am serving the chair of academics.
You are serving this.
I'm
Yes,
Yeah.
you're serving chair, and Pastor Gilbert's on it, and there's one opening.
Right.
And then on community relations, there are 3 openings. On finance and operations subcommittee, there are 3 openings. And human resources has a full membership. Alan Gilbert is chair, Linda Booz, and Laura McIntyre. So, go ahead, did you have something?
Yeah, you
Joyce?
said I was trying to find that sheet where you said you had those open seats. You said the finance.
It's in this packet here that was given to us tonight. You gotta get, I noticed that the numbers are, it's after page 37, the fifth page in. It starts with academics. Have you found it, Laura?
I'm trying to find where your financial chair is. Where's your financial chair?
Fifth page in on this packet here. Yeah, it starts on 34 and then the numbering stops.
Okay.
And then if you get to the fifth page, that's where the academics committee starts. So 34 through 37, the next page is not numbered.
Point of information,
Sure.
you can't have a chair of the finance committee because that belongs to the treasurer. That's an automatic seat.
And that's point of information. That is what our concern is. The treasurer is automatically the chair of finance. And you can't be in a position of president and vice president, and you're trying to hold the treasurer's seat up for the president to come in and vote her in for treasury. That would mean, listen to me, is what I'm understanding what you're saying. Then that would mean that a seat would have to be given up, because according to our policy, the president, if they're gonna move to treasurer, they would be the chair of finance. And you all know that, just like you, the VP, you can't chair in those positions. So you say you guys voted to save the seat for the absent person to take their position. And our bylaws does not say that that person can hold to chair the treasurer or the president. So there's a little conflict of interest for us. So what are we asking for here? I need you to explain it.
Well, I'm not trying to hold anything up. I guess I'm trying to be, let me say, I don't want to say open, fair, in the sense of having all the board members here. Now, if board president doesn't show up tomorrow, I mean, we've got to get something done. I believe she intended to be here today, not through discussions with her, but superintendent called me and said she would not be able to make it. So I'm not sure if something came up or what, but that's the story I was told, and I'm assuming she had planned to be here.
So point of information, so are we saying now that, for instance, if one of us, two of us, after one of us are absent, that you won't make votes and make a decision till we can come back? If that's what we're saying now?
Well, I'm not necessarily saying that, but board president at our previous meeting indicated that she may want to serve as treasurer, and it was mentioned that you can't serve at both positions. So I want to give her the opportunity to decide whether she wants to serve as treasurer, have her name in at least. I'm not saying she's going to get voted in, but to allow her to have her name in. Obviously, this was a contentious thing from removal to now filling. And, you know, on hindsight, I guess the question should have been asked by someone, not pointing fingers here, but so what's plan B? If you remove someone from the position, treasurer in this case, who are we gonna put in there? And there was no plan B.
Well, there was a plan B, since you're not having done it, can I finish?
Sure.
Yeah, then I have,
Yeah.
because I'm trying to get clarity. So you did have a person that, was going to take that spot, and they're not there anymore. And now that spot is open. It is open, because of that situation. So now we still back at the same situation here. So, if you guys are saying now, that we don't make board as a whole decision until we have all 5 people, 6 people here at the table, to make a decision. Because if that person say I'm interested and I'm not here, then you just wait till I get back and then we make a vote. That's what we're saying, right? I just want this for the record.
Yeah, I'm not saying that necessarily. I'm just saying that someone had already expressed an interest. You know, I'm not trying to change policy or bylaws or anything like that with this. Go ahead, Laura.
Mr. Chairman, so what I hear you saying is that you're reserving your vote, so you didn't vote to have a treasurer today because an individual trustee, or we are supposed to act as a board, an individual trustee wasn't able to make the meeting, and you're postponing your decision until they're able to come to a meeting, just in case they want to put in their hand to be the treasurer. That's what I hear that you're saying. I have only been absent from board meetings when I have had COVID or have been exposed to COVID. The times that I was absent because I was doing my due diligence in order to protect the public health, major board decisions were taken. And one can argue they were taken because I was absent and wouldn't be able to object or to bring up points that were pertinent to the votes and to the discussion. So if I hear you correctly, you're setting a precedent. So if I am again exposed to COVID and I'm unable to make a meeting, or if I come down positive with COVID and I'm unable, you're going to postpone the voting for decisions of the board until I'm able to return to my seat or any other member who is here? Because that's what you are doing right now. You have one individual who cannot or will not make it, who has a history of not coming to the board meetings out of protest, and who stated in an open subcommittee meeting in front of other board members and the superintendent that she was gonna, quote unquote, take the district down, unquote. She is not here and you are holding a place for her. We cannot move forward as a district without a treasurer. For example, there are a few more items that we need to discuss under governance. Some of the things need to be paid. You have bills that are coming before the board that certain people are pushing to be paid without proper invoices. They are questionable at best and criminal at worst. We have suspended having a treasurer. We are derelict in our fiscal responsibilities and our duty, and you are deferring to one board member who, in my opinion, circumstantially is holding this board and this district hostage. I strenuously object to the position in which we are being put by this board member and by the support of other board members for this particular board member. We need to act as a whole. This is a committee meeting of a whole. It was called, it was announced, it was posted. We have an agenda. We have payroll to meet. According to our bylaws, the treasurer is supposed to oversee payroll, paychecks for our teachers, for our staff. We do not want to be negligent in our duty to fiscally oversee. That is solely what our board is for. We are responsible for the district and for the fiscal health of our district. And what we have here today is, I'm almost at a loss as to understand why some of my board members are making the decisions that they're doing. I can impugn motives, but I don't do that. I have to trust that you're acting in good faith. But the results of these actions and decisions that are being taken today do not put our district in good faith. I'm wondering, and I need the public to know, why we are not electing a treasurer today, why we are postponing and waiting for one board member who's declined to attend this particular board meeting. If that is the case, then I would make the motion to remove Carol McIntosh as president. I make the motion to remove Carol McIntosh as president so that she may put in her hand to become treasurer. Do I have a second?
Support.
Okay, there's a motion that's been made and supported to remove Carol McIntosh, our current president, from the position of president.
And that would put us in a good position with you as vice president to move to president.
Point of order, Vice President Dale. There's been a motion put on the floor to remove the president from her office. It's been properly seconded. Now we got to go in discussion about that motion. So, the floor should be open for discussion. That's it.
It is. Go ahead.
Thank you, Vice President, Chairperson Del Roney. Now, I feel this is the way that I feel. The motion in the second was proper. It was in order. You can do that. But the thing that I have a problem with more than anything else is that if we're going to do things like this, then we should do them in the proper way. The proper way is for cause. And so that was not stated. That's okay because it was properly done. So I have to live with that. The other thing.
Information, Madam Chair. I keep saying Madam Chair because I'm so used to saying Madam Chair. Excuse me, Mr. Chair. My clause was so that she indicated that she would like to be considered for treasurer, and that was the reason why I was submitting the removal of her as president, so that she could in fact do that.
Thank you. Can I continue? And the other part of it is that we took a vote for a trustee to be the treasurer. The board acted on the basis of a legal vote, and we will act on this legal vote as well. It was legal and it was proper. The board action must stand. Now, if we want to continue to make all of these accusations against people on Facebook and everywhere else that we do things, instead of taking care of business here, yes, we do need a treasurer. We need to take care of business of the district, and that people will get what they're supposed to get. But to my knowledge, Chairperson Del Maroney never said that somebody wanted to be treasurer. He said to be fair. That's his position. He should not be bullied and try to be coerced into changing that. He didn't say he was trying to save a position or get her that position. I didn't hear that. I think that's going too far. It's one thing to disagree. It's one thing to have a different view. But Vice President Del Maroney never said that. I don't know what the president's thoughts are, as God is my witness on this particular issue. But I do know this. The bottom line is that whatever board action that we take with the 5 of us is legal. And that's what we should continue to do. And if there's things that has been sanctioned, approved, board action, the board took the vote. Now we got the rest of the agenda to see to. Let's go to that part, and when we get the next time, we can bring it up every single time we meet to put in anybody that's a board member that's seated to be nominated for treasurer, whoever it is. That's the key. Well, we can keep talking about it, but if we take another vote on putting that treasurer in that position, it will more likely be the same vote if it was somebody else. And everybody has a right to their views. But the president is not here. She don't get a vote tonight. If she be here tomorrow, she'll get a chance to vote. But she's not here. We voted that's legal. It's board action. Let's go on and finish the rest of this agenda and get it done. Come back and visit it tomorrow or next week or the next time we meet, whatever we need to do. But let's do it. The longer we stay here, it's not going to change the vote because we voted. And it was legal. Thank you.
I think what I was trying to hear what you were saying in relates to the president and her desires to be the treasurer. And that my understanding is that you're refraining from voting for the treasurer was to give the president an opportunity to serve as the treasurer. And I was relating to bylaws and policy that your treasurer would chair finance, and our bylaws and policy we operate on that the president cannot chair nor the vice president. So my understanding is that, according to you, that you was, and you can correct me because I'm trying to get clarity, that position that you would like for the president to try to vote and get the votes to take should remain open. And according to the motion that was made by Trustee McIntyre, that she made the motion to free the president up to take that seat based on what you're saying, her desire, what you are her communicating. Those are her desires. So am I clear on that?
Well, the communication was by her to the board when she was here. And she was told she couldn't have both positions. So in the sense of fairness, I mean, even tonight, the vote for treasurer, we didn't open it up to nominations. I mean, there may have been other board members here that would want to be treasurer.
When I was waiting, they could have. The nominating process, when I nominated her, then another person could have just said, well, this is how we have been.
Point of information.
What's your point?
Vice President Del Maroney to Trustee McNeil, you made the motion. And nobody was nominated, you made the motion.
Point of information.
Did you
Point
not?
of order. When I made the motion, you were the chair.
No,
I'm speaking. I made a point of order. Point of order.
Yeah.
Because we're getting clarity. When I made the motion, there was no other nomination because we had opened it up for discussion. Once I made the motion on the second, anyone could have came in and said, well, I nominate myself, I nominate this person. That's what that, open for discussion was.
Well, point of information.
What's your point?
And we could have made an amendment to that.
Wait, now I listen to you. Now you want to keep talking.
Can you do the same too?
No, I don't.
Don't go back. That's, go ahead.
The only point I'm making is that we did it legally. We did it as a board. That's the only way to get the work done. That's the only point I'm making. They can come back and nominate anybody, make a motion at any time. They can do it before this meeting's over if they want to. I don't understand it. That's all that I am saying. I don't want to see anybody from the outside come in. It should be somebody from this board. I don't know who it should be. I really don't. All I know is that I had a right to vote, I did vote, and it was legal. That's it. Thank you.
So let me say this, I'm not trying to hold a seat up open for someone to fill. And I'll take responsibility for not asking the board if there were any other nominations or self-nominations. So that's on me. I don't believe that moving from today to voting tomorrow, and you know, I mean, I won't be chairing those meetings, but my commitment, if I were chairing, we're voting tomorrow. I don't know that much will transpire within 24 hours. I don't expect a finance committee of the whole. I just don't see any immediate pressing issue that we feel tonight. And we haven't filled it because there weren't the 4 votes. I would not ask tomorrow night again to say, well, let's put it off for 2 weeks or whatever until next month. We need to move forward, and if someone doesn't want to move, you know, they get left behind, I guess. I'm not sure how to word it. But my intention is to simply move this till tomorrow, let someone who's expressed an interest do that, whether they want to give up one position for the other or whatever, that's on them. But that's where I'm kind of at on that. So help me get my bearings. Is there any other comment? Do we have a motion? We have a motion on the floor.
Correct.
So are there any other comments?
Are we still on discussion item A? I think we had moved to B, but we still in discussion. We're still in discussion of A.
Yeah, and we shouldn't.
So are we moving on?
So
Point of order.
Okay.
what's your point?
I would ask my colleague to talk in the mic so we can hear her. She's trying to help our colleague over there understand where we are. So we know that it's proper and that we're all on the same page. Thank you.
Repeat the motion.
The motion was to remove Carol McIntyre as president so that she could be on as treasurer.
Is that correct? From the
Yes, and for the record, point of information, I was just saying that there was a motion on the floor to redirect the meeting so that we all would be reminded there's a motion on. Thank you.
So is there any other discussion on the motion which is currently on the floor? Anybody? Okay. So we will do roll call to remove the president. Is that correct? We're all with that? Okay. Board Member Linda, who's
To remove the president?
yes, to remove our current president, Carol, from her position. Board Member Laura McIntyre.
Yes.
Board Member Joyce Allison Neal.
Yes.
Board Member Pastor Gilbert.
No.
And Board Member Christelle Maroney. No. So the motion fails 3-2, one not present, and one open seat. Can I move on to? C, yes, adjusting meeting agenda time. Again, that was yours, go ahead.
Due to the long hours,
So we finished with B, what was the, what were we gonna, I'm kind of unclear about what B was and B.
I can understand what you're
I'm
saying.
so sorry, so we're moving on to C. Was B, what was the conclusion of B? There's no conclusion?
No, just, I mean, that is not the only seat open.
Okay, I just was seeking
Sorry.
clarity, thank you.
Okay.
Go ahead.
Sorry.
Board Member Trustee on the floor.
I'm seeking support from the board that our meeting should last to 9 o'clock. After 9 o'clock hour, we should adjourn and move it over to old business by next meeting. If we have any, for 9 o'clock, we should have everything done. And that's what I'm seeking for, so we can get out here earlier and everybody can go home early. 9 o'clock, so after that, all we do is debate and argue back and forth.
Did that come?
It's not a motion, but I'm just seeking conversation about that, because it's just an informational session as well.
Go ahead, does anyone have comments?
I do, I agree, because, okay. I agree, because last Wednesday was ridiculous. We were in argument up until back and forth, the members were in argument back and forth up until about 10 o'clock, before any of the presenters were able to get up and speak. We had 2 presenters out there, one from Lansing, I know. And I think it's very disrespectful. You know, we didn't get a chance to have second comments from the audience or anything. I left out of here at 11:50. I should choose to leave because I figured that the only thing that was going to happen was arguing back and forth after midnight. And we had several items on the agenda that didn't even get covered. Now, we say we're here for kids. Tonight, the only thing we discussed was each other. I mean, going back and forth, that's all we talked about. And what time is it now? So, you know, if we started at 5:30, 6:30, we shouldn't be here past 9 o'clock at night. That's not normal.
I agree with that. Pastor Gilbert?
Well, I disagree with you and my trustee. He has to acknowledge you, not me.
Okay.
So I'm
Oh, I
talking.
understand. I understand.
I didn't interrupt you at all.
Well, I meant to say,
Well, he has to acknowledge.
not to be here after 9, if we're doing business, it's okay.
Pastor Gilbert, you have.
I have the floor. I didn't interrupt you.
Okay. I understand.
The only thing that I'm saying is this. The reason that we don't get along and we can't get along, the main reason is because we're trying to get even with one another. That's my position. That's the way you're a board member, so I said we. I didn't say you, I said
I
we.
understand that.
And so we understand that you're a board member too. And so, and all our righteousness is as filthy rags. So we have to be careful throwing stones at other people.
Not throwing stones.
Well, that's what I'm saying. I didn't say you did. I said we. I didn't say you.
Point of order.
So-
Point of order.
What is your point?
Can we please keep the topic germane to the agenda and not make personal accusations and slurs against other board members of the board as a whole, please? Can we get back to the agenda?
Point of information. When did the trustee do that so far tonight? Have you done that tonight?
Point of order.
I'm asking you, I'm making a quick inquiry.
Mr. Chair.
Call for the question.
So, we don't even have a motion on the
No,
call.
you have.
So this is supposed to be some discussion about adjusting meeting agenda time. So far, I've heard we want to go just till 9 o'clock, shorten the length of the meeting. I mean, we can start them earlier. We need to keep on topic in general at our meetings. And, but you had the floor, Mr.
Thank you. That was going to be my segue in. One of the reasons we can't take care of business, or we're not able to do it as a board, is because we're too busy trying to chop one another up at this table. That's the bottom line. The business should be done, and that's the only thing. I don't care how you feel about me. I don't care what you think. You don't have a heaven or hell to put Gilbert in.
So,
And so, let me say this, and I'll shut up, Brother Chairman, because I feel the Holy Ghost. I know that they dislike me. There are 3, maybe 4 board members that dislike me.
Point of order.
I'm speaking. He gave me the floor. I'm going to be
Point
finished.
of order.
Let me finish. I'm going to be finished.
who had the
Let me finish.
Point of order.
Point of order. Your point.
This is not a lecture or anything. Because this is speculation. We ain't asking for the Holy Ghost. But we're talking about adjusting the meeting agenda. We all have our opinion, what's what and why. That's not what we're here. It's adjusting the meeting agenda to a reasonable time. Thank you.
Okay, so that, we all know that's our topic and that's where we should be at. Do you have more?
Yes, I got some more. Thank you.
Adjusting the time.
That's my position, is that if we would do that, we wouldn't be here all night. If we would take care of what's on the agenda and get motions to make speeches because you have an audience of political candidates out there. That has been done before, but nobody seems to make mention of that. So all I'm saying is, it's more than one way to look at this. Since we all love the district and we all love the kids, I can hold my peace. I can keep my mouth shut. It's tough, but I can do it for the kids. But I will not sit here and allow people to attack me as an individual and then try to claim that they for the children. All on email. I know, wait a minute. You can have me removed.
Point of order. The chair has ruled. Point of order, please respect the chair.
If you could keep it just the agenda time on adjusting meeting agenda time, that's the topic.
The only thing that I'm going to say, and I'm going to let it rest, is that take care of what is before us. That's what we have to do. And forget about everything else. Who's been appointed, who's been elected, who the people serve, and all of these things. Take care of business. We hear all of this every meeting. Who's been appointed, who's been elected by the people. We hear this every meeting. Who's been a victim? That's where our problem is, in my opinion. And that's all. If we would do that, we would get through our meeting with no problem. Thank you.
Does anyone wish to make a comment here? What I'll say is, yes, our meetings go too long. They become to the point of exhaustion.
We're sitting here, you know, I guess we can bring in our own food, I'm not asking the district for food, but, you know, maybe someone's got to go to the bathroom or whatever it might be. And it's just like an endurance race, and we're tied to the table, but, so I'm all for working to cut back the time. Personally, what I would like to see happen on a trial basis, you know, have some norms, one person speak at a time, wait to be recognized, stay germane to what we're talking about, and not get off into a tangent about something that happened 2 years ago when most of us weren't here on the board, because I don't know, I can't pick sides, and it's, you know, it's water under the bridge, over the dam, wherever you want to have that water go. It's nothing we can deal with. But yeah, I don't know if moving the meetings up earlier, I don't know how that goes with the administration. Kiana, I mean, instead of having a meeting at 6:30, can we start maybe at 5:30? It may not shorten the meeting, but at least it gets us out earlier.
Point of information. Keep in mind, you have your executive team, your administration, they get off at 5. It has been established that our meeting started at 6:30. They have to have time to get here and do everything. 6:30 to about 9 o'clock, you know, because we're not getting, that's what that whole thing is about, is that 6:30, let's allow administration, get off at 5, they can do whatever they have to do.
Yeah, and if that
I'm
was
sorry, didn't I hear you? I'm sorry, that we have to allow 6:30 for administration, who works at the
Board
phone.
members, some of us are paid for.
Yes, so,
This isn't what I get paid for.
Point of order. Who had been recognized?
well, I recognize Joyce there, and
I just thought, so we can just get through this, it's not gonna be, all of the rules is not gonna work, so whoever else wants to speak.
Linda.
Yes, when I mentioned that we need to be out here at least by 9, that's just a, a standard. If the agenda is long, sometimes we may have to be here until 10 o'clock, but we shouldn't be here close to 11, 12 o'clock.
No, that was, yeah, we weren't really into the agenda that much, I think.
Right, and if we can, stop the argument and just move through the agenda, that would be nice.
And we have to,
I know the personalities on this board is kind of hard, but we need to move on because we can't talk about kids and constantly going at each other when we should be doing business.
I agree. So I think that's something we can work towards, obviously, so what I'm hearing is that the starting time should remain the same. I was just throwing that out there to see if it might work, so if the starting times need to remain the same, that's fine. And then we, as board members, as a board, need to work on staying on topic, not, also not bring up things that happened ever how long, you pick your date, whatever. And that should move the meetings forward. Now, it'll take who's ever chairing a meeting, whether it be a subcommittee or whatever, needs to do that, needs to bring it back, bring it back to topic. And no one should take offense to that, because we're here to work on the agenda and whatever else may come up. So I think it's all, we need to work on it as individuals, and we need to work on it as a board. Anyone else want to comment on that?
And also, I've been working on different MASB and legal teams, observing us as a board. And what they are saying is that we stick to policy, stay with the policy. That's all we have is policy and bylaws. Then we won't have this problem. If it gets heated, board has a right to ask for a recess. If the audience do not want to respect the board or respect what we have requested, you can ask for a recess. There's a way to do this very professional and be out of here in a timely manner. And that's where I'm at. If I can get back to policy, I can refrain from a lot of things. We all been insulted. We all have been abused and accused of stuff, but let's get past that. Every day is a new day to do something right. And I would just like to shorten the time. We have young mothers here. They have a right. They work from 9 to 5. They want to go home to their babies. They want to go home to their husband. They want to go home to the dinner table. And we the board, has no right to violate that family relationship that they have. And I'm just recommending 9 o'clock. And we got to look at how we do things. You do not put presentation on with an agenda. Closed door meetings. It steals from the public. So we have to look at that as a board. We didn't have to have all that in one meeting. Presentation is a special meeting by itself. So it's closed door. Why should they have to pay? They come here to speak, to listen, and go home. So we need to make a decision how, if we're going to leave early, and then as government, which is you are, then we can make those changes. Before an agenda is made, according to training, it must be. The board have to see their agenda. The board, 3 persons at the most. You can't get the president to do it. 3 people can say what they want on the agenda. The president has no power. We answer to the board. President answers to the board. So let's make changes as we go. Get the agenda. We see too much on it. Governance, we're the board secretary. Actually, board secretary. You look at it. We talk about it, and then we move on. This is a long agenda. We have to make changes to it. We have not been given that privilege and keeping it at a time frame. So committee stuff and presentation, let's look at doing it on another day. So people can go home to their family. Thank you very much.
You're welcome. Anything else on adjusting the time? Oh, I'm sorry.
You did ask me about administration, and obviously we're working during 8 to 5, so if the board calls a meeting, we would be available as long as, so we're here and we're available, and we're here at 6:30 as well, to facilitate the business of the scholars. So that's why we're here. But if there was a meeting time that we needed to meet earlier, I know for some committees, it does work for them to meet during the day, based on the membership. We're willing to do that as well. We just schedule it as a part of our day. So if that's something that we need to be flexible with, we're more than willing to do so.
Thank you.
All right. Thank you. All right, so we're going to move on to open board discussion regarding...
Well, we haven't decided whether we're going to shorten our time to about 9 o'clock. In about 9, because she just, Assistant Superintendent just said that we can make some provision for coming in a little early. So then, if we can do that, then I can say that we can, for those that can, we have to be consideration not to do a poll for those that are working. But we still can say a certain time that the board meeting can.
So, do we have a motion on the floor?
I would like to make a motion.
Right.
For the board meetings to end at 9 o'clock.
Is there a second?
Support.
Okay, any discussion? I will just say, I don't have a real problem with putting a time limit on it, but if 9 o'clock comes and we're in the middle of a vote or discussion, debate, or whatever, finish that up.
Yeah, sure.
So if we can put that on maybe as a friendly amendment to continue with the current item that we're on. I don't have a problem supporting that. So I'll accept a friendly amendment on that unless, I don't know if I'm going to do a friendly amendment. Okay, so there'll be a friendly amendment to the motion, and is there a second?
Support.
Okay, it's been moved and supported to place the friendly amendment on with the current motion. Discussion on it, Pastor Gilbert? No? Okay, anyone? All right. So we will vote then on the friendly amendment. When I call your name, signify yes for support and no for no support. Board member Linda, please.
Yes.
Board member Laura McIntyre.
Yes.
Board member Joyce Ellis McNeil.
Yes.
Board member Gilbert.
Yes.
And myself, yes. We'll move to the vote on the full amendment now, or on the motion with the amendment. We've had discussion on it. Board member Linda Booz.
Yes.
Board member Laura McIntyre.
Yes.
Board member Joyce Ellis McNeil.
Yes.
Board member Gilbert.
Yes.
And myself, yes. So it passes. So we'll try and conclude the meetings at 9 o'clock, unless we're in the middle of something, we'll finish that. And we'll try and stay on topic. So we'll go to D then, open board discussion regarding chat.
I would like to.
That was yours, go ahead, please.
Okay. We know that this item has been on, I think it's on our call, on our regular meetings. I'm going to go strictly and carefully and to bring the public up to the point where we are regarding open board discussion regarding the check.
Excuse me, board member, just for information, can you tell us what check you're referring to?
A motion by Treasurer Green, second by Trustee Gilbert, that her legal fee, the money she spent, the money she may have to spend to be paid for. That is what this is about. Treasurer Green wants to get reimbursed for the money she spent on her lawyer fee as it relates to the case against Trustee McIntyre. I want to, without interruptions, please, and let us refer to policy. Page 63 of our bylaws. The board should run a decision which are not inappropriate influenced by the personal business interests of board member. To this end, board members are required to disclose any actual or potential conflict of interest prior to the vote or on any matter, contract, or transaction involving the district. Furthermore, board members should abide by the board's conflict of interest policy number 5230, which is, I believe, is on page 32 in your policy book, and the applicable Michigan statutes. If it is determined that a conflict of interest does exist under the state law or board policy, the board member should abstain from voting on the matter, contract, or transaction. That is one of the issues that we have here. The treasurer made a motion to get herself paid, which is a conflict of interest according to bylaw 1350 and our board policy 5230. Because of that vote, which the treasurer made, it sends us back to Robert Rules of Order, Article 347. It speaks on votes that are more and lower, even if unanimous. If the question is undebated or debated, has been closed by order of the assembly, the chair immediately after stating the question. Is a response to Danielle Green's request because it violates the policy and the law that this vote should be void according to Robert's Rules 847. And I believe you guys had a copy of that we had last week, talking about votes that are null and void. If it violates the Michigan state law, your board policy, even if it's vote unanimous, if it violates that vote is null and void. On that note alone, I just don't think this discussion should go further into it further because it violates the policy. That's my opinion. That's what I read from the policy.
Thank you, Vice President Gilmore. First of all, we took a vote some time ago to pay for a trustee's legal fees. I said no then because I thought it was a bad precedent. I thought it was a bad thing to start down that road because of then former board member Danielle Green was not here, and that we would have to consider her fees as well. And I voted no then. I voted yes because that the board voted to pay for someone else's fees. And there had been no decision made by way of legal or policy, and that is your interpretation of the policy. The thing that I wanted to be known as far as Trustee Gilbert is concerned is that I was never in favor of anyone's legal fees being paid by this board. Anyone, whether it was former Trustee Green or Trustee McIntyre, because I think it was a bad precedent, and I still feel that way. And the bottom line is that the legal proceeding that took place was outside our purview. And so that legal proceeding involved both trustees. It involved both of them. And so as far as
What is your point?
I was not a party of those legal proceedings. I was merely a witness. So please correct that. I was never a party of any legal proceedings.
is that a point of information or what?
Yes.
Okay, thank you.
So,
Thank you.
let me just say this real quick. What happened in the courtroom for myself, I really don't know in the sense that I wasn't there, I wasn't asked to be called in as a witness. We were all asked to write statements after the event, the altercation, the assault.
Point of order.
Where's the point of order?
Point of order.
Hey, what's your point?
The agenda on the table is speaking about not the child who did what, none of that. The issue on the table is that Danielle Green would like to get reimbursed for her fees for the assault on Laura McIntyre. She made the motion. The policy said there's a conflict of interest, and she at that time was the treasurer to authorize and pay her own check. And the policy states that you cannot do that. She have to, any treasurer would have to abstain from that. That vote that was taken is voided because it violated the policy and the laws, the state law. This laws, the state law we have. Robert Rules of Order 847 speaks on that. Now we're talking about policy. Now the board has the information in front of them. It is about who did who, who ran who. It is not that we're trying to make a major decision. For the record, we're talking about policy. And that we have to go back to what the policy said. That's why we have to have a treasurer. A treasurer cannot rubber stamp or vote. To get paid, they have to abstain. If someone else had made that vote for the treasurer, and the treasurer would have to abstain from that vote, we can get those, then that would have been different, but the treasurer voted for herself.
Point of
I'm
information.
just speaking what the policy say. Thank you.
I'd like to,
Yes, Mr. Point?
yes, to the chair, to the trustee, is that when the vote was taken to pay for trustee McIntyre's fees, what conflict was it there?
I would like to respond.
Go ahead.
The opinion that came from the Trump firm talked about a case on policy of government negotiation does address this issue and clearly allow Board of Education to pay for service of an attorney for board member regarding action taken on behalf of the board. In Board Member McIntyre's situation, she was participating in a board meeting discussion when she was assaulted by Dr. Green. Based on those facts, Board Member McIntyre's legal fee should be paid. On the other hand, Dr. Green's assault of Board Member McIntyre was not done on behalf of the board and did not arise out of board member's duty. At this time, there is no business case law that interpret this statute under those facts. So the board should take this fact under consideration before any payment is issued for Dr. Green's legal fee. And that's why I went back to our policy. The treasurer cannot endorse himself to pay himself. Is a conflict of interest, and that vote that was taken is according to Robert Rules of Law 847. When there is nothing in the policy that speaks on no votes, avoided votes, our policy said we return to the Robert Rules of Order 847, and that vote is no. I didn't write these policies, they was there, I'm just repeating them. And I read the legal opinion that we have, that I had from Trump as it related to Laura McIntyre's case.
Point of information, Brother Chair, to the trustee.
And that's, that was on my house the 30th, and that was the second opinion.
Well, I have a point of information. It would be nice if you would stop talking.
Yes, sir.
Go ahead.
Thank you, I appreciate that. The only thing that I'm saying is that I understand that. I read it twice, I understand all of it. And the bottom line is, if this board decides to pay for former Daniel Green's legal fees, it would not be illegal for us to do that. If that's what we decide to do. And if, because we decided, not me, but the board decided to pay trustee McIntyre's legal fees, I was against it then, I really have always been against it. But if you're going to pay for her legal fees, my position is this. And I want the record to know, and I want the candidates to know, and everybody in this city to know, that former trustee treasurer Daniel Green's fees should be paid as well. That's my position.
Board member McIntyre.
So the distinction, and I can appreciate how a trustee might be confused by some of the superficial similarities between the situations, but they're quite distinct, actually. The board unanimously agreed to remove the former president in her role as president. We voted unanimously. We agreed as a board that her behavior was abhorrent and beyond the scope of her responsibility, and therefore she was removed as president. We weren't able to remove her from the board because that would be against the state statutes. Only the governor is allowed to remove a board member. And this was her behavior, her actions, what she decided to do was not within.
Point, sir. Yes.
Go ahead with your point.
We can't relitigate the case. The case is over.
Point of
and it's
information,
done.
I'm reading the true legal opinion that is.
You're not reading the legal opinion of Trump, you're reading what the legal court proceedings were. We're not.
Point of information.
We're not.
Point of information. Point of order. Please let me have the floor. I'm
Point of
referring.
order.
Point of order. I think, point of order, we're in a discussion. The public needs to hear the details, as though I just demonstrated.
Point of order.
Are we going to do point of order to stop
Yes,
this?
we
Point of order.
may have to do that.
Point of order.
We may have to do that because you have a motion on the floor that Daniel Green's legal fees was not paid because of policy and what Boone law
Let's make
said.
a motion.
Yes, you do.
We would have
It's
this.
part of the agenda.
Point of order.
Yes.
It's
So,
part of the agenda.
the check is part of the agenda.
Yes.
Point of information.
Hang on. Go ahead.
Point of information, there's not a motion on the floor. We are on D, open board discussion regarding check.
Absolutely.
Okay, thank you.
So-
May I please resume the floor?
If I can make a point for us.
Yes.
I think what you're reading is the true legal opinion
That's right.
regarding payments. And I believe that came over our devices
It is.
as confidential. So,
That's right.
whatever, what's your point?
We are having a discussion, and that meant that each board member has a right and a duty under oath for their elected position to have this discussion. The agenda said an open board discussion regarding the check. Let that person speak that out, and it's painful, I might not want to hear, but so we can, this is what we just talked about. Let us have some order and not misuse point of order.
So if you didn't want to discuss it, you should not be on the agenda. This is, and I'm not disclosing anything that.
Point of information.
Point.
And this is my last one. I'm gonna let them do whatever they want to do. But I want to know for you, Madam Chairman, to the trustee, what is your point? I just want to know what is your point by going through this, if it's concerning the payment or not to pay the legal fees of former trustee and treasurer Daniel Green. That's all I'm asking, Trustee Mack. That's all I'm asking you.
So if I.
Mr.
if-
Chair, may I please
Okay,
resume?
I will just say one more time that I don't believe this legal opinion came out of a closed door session. But along the top, it says confidential attorney-client privilege communication.
Point of information, once we get a legal opinion, then that is for the board. Once the board see that legal opinion, the board cannot talk about that legal opinion. If it was closed, and you cannot do closed door. In this regard, closed door session has very strict rules. This could not be a closed door session, and it have to be open to the public, to the taxpayers, and so they can see the decision. Closed door session has very limit what we can do in going to closed door session. And that is why we're having this, you all gathered, we're reading it, because it's public information, because this is a public meeting, not a closed door meeting.
So if I may, Mr. Chairman.
With what I said, go ahead.
So as I was saying, the board unanimously voted to remove the former trustee from her position as president because her actions and behavior were beyond the scope of her responsibilities as a board member. She was subsequently sentenced by a judge, and after that, she made a motion as the treasurer to pay a check to herself, which is against policy and bylaws. So therefore, that particular motion should be null and void. Because it's against bylaws, but it's also ethically questionable. So as a board as a whole, we did vote to remove her because of her acting beyond the scope of her responsibilities. And the legal opinion was that because I was chairing a meeting, an open meeting on the school grounds, and was acting within my scope of responsibilities, that we were allowed to pay for legal fees, not of which I was not a defendant or I wasn't a party in any way or shape or form, but I did have to, I was asked to provide legal representation from the judge.
Okay.
And that was to defend my scope of responsibilities as a board trustee. Now, that is not the case with the other party, because she was not acting within her duties as a trustee, as a president, or even as a regular trustee, so it's not defensible. And that was the opinion of the judge. Now, we may consider paying for her, but that it's not that we shall, but we may. The same as shall, don't have to pay Laura McIntyre's fees, but we may. And because I was acting in the scope of my responsibility, we decided as a board to do the right thing. And I think the question to ask, is it fair? Is it reasonable? And is it just to ask the public, to ask the scholars, the children, the staff, to pay for the unsanctioned actions of a board member who's acting outside of the scope of their responsibilities as a board member, which include physical assault when we have a zero tolerance policy in the district? What kind of a message are we giving to the district? So is it fair? Is it reasonable and just? And I would argue that it is not. And it is, again, our fiscal responsibility and our duty to do the right thing. I was acting in my role as treasurer, as the chair of the meeting, when I was assaulted, doing that, on school board property, and then that's the legal opinion that came down. So it is up to our discretion.
Pastor Gill.
Thank you, Chairman Chris Gilmore. I would like to, as a point of information, ask our trustee McIntyre, has your legal fees been paid?
I do not know, actually, whether the invoices have been paid or not, because I was removed as treasurer, so I don't know what the status of those invoices are. I would like to say, though, that I do have invoices that are itemized in detail and not just a Visa check receipt with an undetermined number that isn't really defined. I mean, we have some bills that were submitted, but we don't know exactly what they're for.
And if I may, just continue shortly, is that I know how serious the situation is, and that was my reason for voting no from the beginning. Because I felt like this would come in, and it's not part of the district. This is legal proceedings. This is what happened between two members, even though it was wrong. It should have never happened. It should have never happened, but it did. It did happen. And all that I'm saying, just let me finish, is that when we started down that road of paying for one member and not paying for another member, this is why we're here. That's the only point that I want to make. Thank you.
On information, when the attorney was making these decisions and getting these different legal opinions, and they say this is for all board members, we are bonded. If we are attacked doing board business, we was in the middle of an administration building doing board business. What's your Go ahead.
Is it possible for the legal throne whoever to come and break this down and make this plan?
Point of information, point of order. I would like to continue
Go ahead.
Yes.
Yeah,
We, as board members, if something we are attacked, doing board business, assaulted, and we have a right, we're bonded, but we have a right to be, not to have legal fees paid. We brought that before the board, it was voted on and passed. If I decide to get up and hit Ms. Booz in the middle of board business, I am out of order, I'm going to be charged. Ms. Booz has her day, if she needs an attorney, according to what we understand, the board have to pay for her attorney. She's here on board duties. We do not reward people for the assault. It's not a board duty. We are, as board members, we are bound by policy, a regular policy. We pay big bucks to get these legal opinions. We get them. We have proper rules of order. But when there's a desire and a passion of the heart to do something different, we have been here all day. We stated the policy. We stated why that this board should not do this. And it goes beyond the scope of policy and bylaws. We're talking about ethics and accountability. And we have to do the right thing. On the 22nd, 3 board members have to go and make decisions on expulsion. And we have to judge these children on policy. We are holding them to the ground on policy up to 180 days. But here we are, board members, going through policy, going through parliamentary. We're not even talking about court here. What was violated? What was violated? I spoke when I hear this expulsion hearing of these children, of these students. We are holding them to policy. Now, we might have passion. That's one thing. But passion is not, we took an oath of policy. If it was up to me, I wish this thing has never happened. But it happened. My heart goes out for both parties because we have denied our board. Terribly. I can take insults. I can take lies. I can handle it. But I would not sit here and get to Wednesday, have to hear an expulsion hearing, and I'm going to sit there before those kids. I'm not going to do it. It's policy, and it's what is right. And they violated policy. Bylaw 1355 and your own board policy 5230, conflict of interest. You voted for yourself. And Robert Rules of Order 847 said that vote is no. That is where we at. We have to make a decision based on policy. Yes, you might get beat up by the public, you might get the JA award and all of that, but you done it right then when you stood upon policy. So I would like to make a motion at this time.
Go ahead.
I would like to make a motion that this decision to pay Dr. Green, reimburse her for her lawyer fee, be denied. Wait a minute, I think that's the right one. I rescind that motion, let me think that through. I'm trying to make a motion.
As you're looking at it, I would like to say that,
Oh, I know that I did wrong when you get time,
is that,
okay.
it appears our bylaws need to be updated on this matter. Or not specific matter, but something that, like this had to go. What I'm understanding is a motion was passed at some point for,
August 17th.
well, no, I'm talking about for, Board Member McIntyre to be paid. And then on the 17th, the motion was passed to pay, Danielle.
Based upon legal opinion.
Yes. So we've got these legal opinions, and they're kind of vague. We can do it, we don't have to do it, and so that's why I think the cleanup needs to be done. But having said that,
Point of information.
go ahead with your point.
The legal opinion is the opinion, then also based upon violations of policy. We said we would look at the legal opinion, and gave a legal opinion was good enough for me. However, based upon policy, I would think that we need to do a reconsideration motion according to Robert Rules 847, because it's a violation of policy. In policy for a treasurer to vote for a transaction of themselves is a conflict of interest. So we have a legal opinion, and once again, we have two violations of policy. And that's where the reconsideration of that vote, it should ignore and vote it out because it violated policy along with legal opinion. But the violation of policy alone rules out the motion. We need to, that motion that was sent out that everybody's holding on to based on legal opinion, I am making a reconsider, I move to reconsider that vote because of the violation of policy as it relates to opinion of Dr. Green because they have violated policy. And that's where we are now. It violated policy. It never should have been moved. We have people in this board that are expert in parliamentary procedure. That is in your bylaws. The treasurer cannot vote to pay herself. In regards to the confusion of the throne, the first violation was policy violation that Robert Rules 847 speak to. And we need to reconsider that because it is automatic, voted out. So that motion needs to be reconsidered. We have to reconsider that. Are we reconsidering this motion based upon policy? Where does the board member stand on policy? So, Madam President, if we want to, are we still in the motion to reconsider this vote?
Yes, we're still in discussion.
Oh, you're in discussion.
Pastor Gilbert.
Point of order has been made, has a motion been made to reconsider or to rescind, which would take 2/3 of us that are present. That's in Robert rules as well. So if you're saying that it's illegal, that what happened on that day to rescind, to bring it back, you're saying it's null and void. It's not. It's board action, because the words that are written therein is may and shall.
Point of information, Robert Rules 847. Even if that vote was unanimous, it is void because it was an illegal vote that went against the policy of the board. There's no vote needed because it violated policy. You do not need a 2/3 vote when you voted against policy. That's what Robert Rules 847 states.
Trustee, I think you're incorrect.
But get the book and show me. I'm reading it right here, Pastor Gilbert.
I
However,
know you're reading, I understand. You sent it in the email and I read it. I know exactly what you're talking about. But I think you're incorrect when you say the board action was null and void.
the vote,
wait,
I said the vote.
the vote, okay, the vote. So the vote that we take today, so you're saying that would be legal? Is that what you're saying?
Point of information. I'm saying that that vote that the treasurer made for themselves void because it was an illegal vote for them to even sit there in that seat and occupy the treasurer's seat to vote for themselves. Robert Rules 847 state that that whole motion is void. It's in the Roberts 847. That motion is void because it violated policy, conflict of interest. That's why we have to have treasurers and follow the rules. That motion that we're trying to push forward is void because your treasurer made a motion, Gilbert, you seconded, and when we went back and looked, we had a discussion and get the minutes, and that was a void vote because you cannot conflict of interest. That's why we have this policy. So Robert Rules of 847 says that vote, that motion is void.
Now, what I'm saying is that I read that decision from Bloom Law through the email. Then I read it again by the paper I already had. And it has been stated, you may or you shall. It is up to the board to decide. So if you're correct and I'm wrong, you're correct and I'm wrong, then the board must decide. If you're saying that 847 means that the vote that we took that particular night was illegal and wrong according to policy, you may be right. I don't know, but I don't trust that.
Point of information.
And I'm not finished. Well, go ahead. What's your information?
Point of information. Go to your bylaw. Conflict of interest. I believe page 19.
I read it. I trust
But
it.
you're talking about violation of policy.
I don't believe it was a conflict. That's my opinion. That's
Well,
just my
I'm just reading what it said. It didn't ask us what we believe. That's why we have the law. Some people believe it's just not their real life, but that doesn't make it.
But we're not talking about
Well, I'm just giving you.
We're talking about payments.
Just one at a time, please.
Well, she made the comment. I think your interpretation is skewed. That's just my opinion.
Board Secretary, could you read that here? We have two policy violations. Page 63 on the bylaws.
Point of information.
There's your point.
Hasn't that been read? Did you read that? Hasn't that been read? It don't have to be read over again. I understand. I just have little view about it. That's all I'm saying. It's up to her if she's gonna read it. I can't stop her. But all that I'm saying, let's go on with the vote and let's get the decision made.
Well,
We're having a discussion,
so,
and the board is making a discussion. Why are we having this discussion? Because the treasurer voted for herself to be paid. And we have a discussion to make sure that we are in order. We look to make sure that if there's any policy violation, which we have found, and we looked at the opinion, which states pretty clearly depending on where you stand on that. And I believe my understanding is, Chris, come back to the chairperson to make sure that I got clear understanding what is to come from out of this discussion. What are you looking to do from this discussion?
Well, it sounds like someone rescind, reconsider the actions of the board regarding the check. But what I'm also hearing is that simply because of the fact that then the board treasurer voted for the payment for herself along with others.
And point of information, also made the motion.
Okay.
She made the motion,
Okay. So that action in and of itself would require that the vote be null and void. Is that correct?
Yes, correct.
And at the same time, the board, all that aside, could have and could maybe still decide whether payment is made or not. There's nothing that precludes the payment. If I'm understanding the legal opinion.
When we have the meeting minutes, we voted, not all of us, to consider the payment given the legal opinion. So we were waiting on the legal opinion. We subsequently received the legal opinion, we also received the judge's opinion. And so we agreed to move forward with a decision after that opinion. So the decision has not been made. So technically, somebody else could make the motion, not the former trustee, and could bring that motion forward if you want to bring the motion
Point of
forward.
information, at least tonight, I agree with my colleague. That's all I'm saying. We can disagree about what we feel or what we think and what we believe. But if we're going to take action, take the action. If that's what we decide to do. If you want to wait till later, we can do that. But if you're going to make the motion, we discussed it, and let's make a decision. That's my position.
Through the chair to the trustee, is he making a motion to?
No, I'm not making a motion.
That needs to be made, respectfully, if he would like those, if you'd like to make a motion, you can make a motion. But as it stands, there's a conflict of interest, and you cannot have a treasurer making a motion to cut yourself a check and give yourself a payment.
Right. So that, all that being said, the last paragraph, next to last, in this instance, the board must weigh these factors and there's several public opinion and things like that. Must weigh these factors when making the decision at the board's discretion as to whether the board should pay the legal fees to Dr. Green despite these drawbacks. So that's kind of, in my opinion, giving us permission to pay if we want to, but at the same time, the previous vote was illegal simply because we had the current treasurer at that time make the motion and vote for her payment. Is that correct?
That is correct, based upon Robert Rules 847. A lot of time we sit here and we make motion, we say yes, then you go back and look at what the policy says. If there's a violation of policy, what they did on August 17th, that motion is voted out. Now, if another board member wants to try, but that's motion here tonight is voided because the person, the treasurer, voted for themselves. So this is voided out, no vote is needed because it violates the law, the policies, and all of that. That is null, whether it's unanimous or not. The vote is voided out. Now, if a board member wants to move forward and make another motion to pay Dr. Green legal fee, and knowing that the issue is voided out, and make a motion, because right now, there should be no checks in the queue to be printed. There should be no check getting ready to go out, because this is a void motion based on the fact that the treasurer voted for themselves. It speaks black and white. So there should be nothing done. If a board member wants to bring this back, we can't stop that because it's your privilege. But we're talking about the motion made on August the 17th that violated policy and it violated your bylaws, which injects Robert Rules 847. When this is done, it's voided out because it was illegal. Now, we should be done with this. You don't have to have a vote. You saw it in the policy, and it's done. If a board member feels compassion that this should be done, then they make the motion, not the treasurer. We can't stop you from making a motion. We don't even have to vote on it. It's voted out because they're illegal, the treasurer. And then we can't be having, come and get, no. This is gone by because of the violation of policy, Robert Rules 847, the person voted for himself, read it for yourself, the parliamentary specialist, and let's just move on. This vote is gone. It's nothing we can do with it. It's dead because it violates policy and the law. Not the opinion. Policy comes before the opinion. If we had known when we was looking at this and going through policy, we would have caught this. But that's why Robert Rules said, hey, you can go back.
Point of information, if I may, I'll ask Trustee McNeil. I read everything that you read. All that I'm saying is that if it's null and void, then there's no more to be said. Is that your understanding?
Yeah,
that's your understanding, right?
My understanding is that the board agreed that the policy was violated, that the treasurer, we can agree to that. Do the board agree that according to the policy, bylaw 1355, policy 5230 was violated. Does the board believe in that you just read? That we have to do this step by step. That's why I asked you to read it. Can we agree to that one point there?
What point is that?
The conflict of interest, bylaw 13.
And the conflict of interest was that the treasurer made the motion on their own behalf. Is that the understanding that you have according to the legal opinion? Is that correct?
I'm reading bylaw 1355.
Right.
It was determined that a conflict of interest under state law or board policy, the board membership abstained from voting on the matter of contract and transaction. So, what I'm asking the board, did that process happen, and are we in agreement that the previous treasurer violated this policy by voting for themselves? That's just, we have a discussion. Can the board agree to that? Just this conflict of interest policy that was violated. Page 63.
Mr. Chairman, those that voted for that to be paid was in violation. So which means the majority on that particular day were in violation of policy. Not everybody on this board voted for for that to happen.
We're talking about the motion
I
and
just
vote.
want to make that
For
clear.
that information, we're talking about the motion and vote that led us to Robert Rules 847 because, bylaw 1355 was violated. That's what brought us to parliamentary procedure, Robert Rules of Order 847, that wiped out that motion regardless of who voted for it. It was a unanimous vote from 4 board members. Yeah, 4 board members.
Point of information, for votes is not unanimous.
No, it wasn't unanimous, but what they said was the majority vote. When I said unanimous, the majority vote, and which would be the majority vote passes. What I'm saying to the board, we understand that there was a policy violation in that motion. At that time, she was appointed treasurer. Once she became treasurer, I'm going to vote for myself, and that is against policy.
Point of information, ma'am. She wasn't appointed treasurer, she was voted on to be the treasurer.
Yes, the treasurer.
She was not appointed.
Yes, she was voted on to
By
be treasurer.
4-vote majority,
Yes.
correct? Okay. That's it. That's it.
So now the thing is that we got to get on one accord. Because we don't want to keep going back and forth. And we can just raise hand. What board member feel that the policy was violating conflict of interest?
Excuse me.
Point of order.
Madam Chair, I was going to ask the chairperson.
Point of order.
What's your point?
Vice President Del Rose is the chair. He asked you to say this.
Well, you can give her a chance to go back.
What you said, what we should do, that's all I was saying to you. He's the chair, not you, not me. That's it.
What's your point?
Vice President Chris Del Rose.
Yes.
What I understand that we should vote, we not to vote and be in agreement. Are we in agreement? You can ask each board member. I'm requesting we ask each board member. Do they agree that, bylaw 1355 was violated? So we can all kind of be on one accord on just that note right there.
Okay, let me ask this question. Can someone read to me the board's conflict of interest policy number 5230? Do we have that somewhere? Well, I'm looking at page 63, where it talks about conflict of interest.
Okay.
But I cannot find 5230 in
The definition, if conflict of interest exists where an employee or board member has a personal interest in a board action or district transaction, it impacts only the individual employee or the board. A direct conflict of interest ordinarily does not arise if a board action or district transaction would have an impact upon a whole class and or category of individual, which the employee or board member happen to be just one member. An indirect conflict of interest exists where the individual is related to an employee or board member and the conflict impacts that individual. A financial conflict of interest exists when the individual will receive a financial benefit if the board section or district section is approved. That's a conflict of interest. A fiduciary conflict of interest exists when action taken by the board or the district with favoring impact, and they go on and on and on. And number 3, if you want to look at it, because that's a long item to read, but it's on in my board is 5230. Yes.
Are you reading from 5230? Is that what you're reading?
5230, page 19 in the computer that I'm looking at because you guys have something else. Conflict of interest, cross-reference 5640.
Page 19?
information,
And this is ridiculous.
we have different paginations for the board's bylaws and the rules. Linda doesn't even have, trustee Booz doesn't have the even pages of the policies on it, so she's skipping a chunk, so just point of information.
Thank you for that point of information. If I may, you are asking that we agree that a policy violation was violated. Is that my understanding from a trustee? That 13.55 was violated, is that right? Or is it another one that you're talking about? The conflict of interest.
Conflict of interest is in your bylaw, 1355, page 19.
Right.
And then your board policy has 5,000 series. You can go to 50, you go to 5230, and it goes on down to 5645. So now, I have stated what it says. Mr. Gilbert has a different opinion, and we're trying to agree that the conflict of interest that the treasurer voted to pay himself financial transaction, and that's the conflict of interest. And the board have to make a decision.
So if I can state this conflict of interest, 1355, page 63. The board shall render decisions which are not inappropriately influenced by the personal or business interests of the board members. To this end, board members shall be required to disclose any actual or potential conflict of interest prior to the vote on any matter, contract, or transaction involving the district. I think we all knew the situation because it was a vote about paying that the treasurer.
Point of information.
Sure.
Point of information, Chair, but that's not actually how the bylaws work. I mean, assuming that we knew because it's self-evident isn't a reason. There still needs to be a disclosure of the conflict of interest. And it needs to be stated, and then furthermore, the party needs to recuse themselves from the vote, including not making the motion themselves. So not only was it voted on, but the motion was made by the same party who was financially gaining from that vote. So that's more than a significant conflict of interest.
Okay, so I don't know where we are. Is there any more discussion? We have a motion on the floor, right?
Point of information, there's no motion on the floor because it's null and void. If a trustee, if one of us would like to make a motion to bring this back to consideration, because we did have August 17th voted yes, barring or waiting for the legal opinion. So if somebody would like to bring it forward for a vote, they are welcome to do so. It is within their rights to do so. But it is not something that we voted on, that's moving forward, that is going to happen, and there is a conflict of interest according to our bylaws.
Point of information, Chair. Because if we, those that voted in the majority to do that particular day, number one, is that the chair, which was the treasurer, should have not voted. That's really the policy. No time tonight that I deny that is not what to say. I asked that I wanted a legal opinion way back when we voted to approve to pay for trustee McIntyre's. I said, but we never got it.
Point of information.
We never got it.
Point of information. Yes, you did. I had to go back and look at all your emails. I sent it out, and then we sent it out the evening before we voted. I sent everybody the legal opinion. We sent that out.
Point of information, yes, we did have a legal opinion on true.
And I read it.
I stand, I'm gonna go and see if I can find it. And if I
Point
can,
of information, point of order. I would like to make a motion that vote.
point of order, you can't do a point of order to get the full so you can make a motion. What is your point of order? You can't do that. It's not right.
Do you have a point of order?
Point of information, a motion isn't necessary.
That's right.
It's void. And I think, if I may have the floor, Chairman, that I don't think that anyone is casting aspersions or accusing anyone who made the vote of voting with ill intent or with dishonesty or with, nobody's saying that. This is a very, if I may, Trustee Gilbert, this is a very confusing situation. I think we're all kind of scrambling for parliamentary rules, for the bylaws, for state statutes. I think, we all have our best intentions of the district. We requested legal opinions. We have 2 of them. And so whether you voted yes or no, it's not an indication of guilt or admission that you were doing anything nefarious. Nobody's saying that. But what we're doing is we're just trying to move forward with policy and to do the right thing for the district. I think we're all clear on that. Is that
Sure.
correct?
I think we move forward on that point, and at the same time, there's been some question on the bills that have been submitted. They weren't detailed enough, so I would recommend that the bills become more detailed and then take up the payment at a later time. Because we've heard it's just a charge card receipt, doesn't say what it's for, go ahead.
Point of information, based on the discussion we had, we all agreed that that vote was no and voided. So I'm making a motion that the board agreed that the decision of August 17 was illegal, and we move forward. That's the motion on the floor. Since we had the discussion.
Second.
Okay, there's a motion that's been made and supported.
Point of order. I understand that there's a motion on the floor, but I believe that we need to take a recess.
Remember,
It is now 8:10.
Let's do it.
I do need a recess as well, and Trustee Lewis has vacated the room.
How long do you want to do
I'm
that?
like, 9 minutes, something like that. It's 5 minutes, okay?
5 is good with me.
If we take a 5-minute recess?
yeah.
Okay.
Thank you so much.
We'll recess for 5 minutes.
Thank you so much. us a weapon. But we did do 9 o'clock, it is 9 o'clock.
No, almost, it's 8.
Are you ready to do this?
Yeah, okay, so we're back from our 5-minute recess. Go ahead, Joyce.
Okay, I want to make a motion, thank you very much. I want to make a motion that the vote was illegal and not to pay based on this motion.
So moved.
Chris?
So there's been a motion made and supported to,
If the board agreed that it was an illegal vote and therefore not to pay at this moment, not to pay based on this motion.
all right, is there any discussion? Okay, I have, Pastor, did you have something? So I just want to get clarity on the policies that we're working from. One is on the page 63, 1355, conflict of interest, where it says basically the board member, whoever it might be, should disclose that there's a conflict and that they should abstain from voting. Is that correct?
Let me rephrase that motion. The motion, maybe it's going to be two motions. The motion is the board agreed that this was a legal vote, and that motion on August 17 is void. And the board need to make a motion that we agree that is the motion on the floor, that vote was illegal. That was a illegal vote, based on the policy violation.
Okay. So again, that.
We agreed to that, we agreed.
1355
1359,
is one aspect of that.
and the one is, I can't remember, 5230 in your board policy.
Okay.
So
I don't have the policy with me. When I first got my packet, I was told that this contained both policy and bylaws. Thank you. I think it was last week we got the new policy breakout, which I thought it was still in here, so I didn't bring that in with me.
which one is it, 5230?
5230, you had said from policy.
That's the one that you want, you got your bylaw, right?
I have my bylaws.
You see it on your bylaw, right?
And what?
You see that in your bylaws.
No, I can't find it, is what I'm saying.
Could somebody give them a copy of that bylaw?
She gave me some copies.
Yeah, I did bring that in with me. So I don't know why when I first came in, I was told policy and bylaws were mixed in.
There's your policy.
This was bylaws.
That's your board policy.
All right.
And it goes all the way down.
Oh, okay, okay. I thought that was, that's just a nice.
Just so I don't go through all this in the interest of time. Where does it say, that it becomes null and void?
This is your, Robert Rules.
Robert's rules, okay, if you could just read that point.
I will have to have my computer. Do you have Robert Rules 847? 847. Do you mind calling up your computer? Then Bruce, do you have a copy of Robert Rules 47, the one I highlighted for everybody to get a copy to?
No.
Remember?
Robert Rules 847.
No, I don't have a copy with me. I'll bring it with me next time.
Okay, thank you.
I guess I'm going to bring my whole office with me.
Yeah. Here it is right now.
If you want to read this public, go ahead, I'll just read it from now on.
Give them the rules of shit.
Okay. Votes that are null and void, even if unanimous. No motion is in order that conflicts with the laws of the nation or state or of the Assembly's Constitution or bylaws. And if such a motion is adopted, even by a unanimous vote, it is null and void. It's in conflict.
It's in conflict with the law.
And the bylaws.
And the bylaws.
Okay, I'm fine with that. Thank you.
Thank you.
So there's a motion on the floor?
Yes. Is there any further discussion? Any further discussion? Dr. Gilbert?
The only thing that I would say is that you can't deny what the Robert Rules of Order says, but procedurally, I think that the 5 votes should come into play. That's just my view, the 5 votes to rescind, to bring it back so that you can vote on it. I could be wrong,
Point of
but
information.
Here's your point.
The motion on the floor is the motion not to rescind. It's not a rescind. It's a different motion. Okay, okay.
thank you. I know.
Yeah,
And so
so
that's my only problem that I have. To rescind it, I think we have to vote to get the 5 votes. That's just my opinion.
Point of orders, Robert Rules, 847, does not, it's just voided. It's just not going back and trying to get 5 votes. It's voided because we broke the law, we broke the policy, we did not follow policy through. And so that is just voided out. It's just voided, there's nothing else we can do. Everything returns back to where it was at. That's what that rule is for. When we do things, Robert Rules states it, when we do things like that, because sometimes we're bored, we do things, we vote. And that was the worst job in 17. Everybody came in with the coop and just rushed through it. But then we go back and look at what happened. We saw that policy was violated. Procedure was violated. And so this was one of them, right? It's just one of them right now. And we as a board is trying to rectify that. We're showing the public that we are following policy, very respectful to the policy and laws that's set before us. And that was a motion on the floor.
and there.
No, we were discussing.
If I can go back to 1355, I just want to read this first sentence here. The board shall render decisions which are not inappropriately influenced by the personnel or business interests of board members. So it covers both if they have an interest in a business, say maybe a vendor that comes before us of some sort, and also if it's a personal thing. And I would think this would come under personal in the sense that it involved payment to the, at the time, then treasurer. You know, so that being said, I just want to say also, there's nothing wrong with bringing in more detailed receipts for us to, let me say, maybe look at this again. Just because what I'm hearing is the receipts, I don't even really know the total amount.
Point of information, because of the vote and the violation of the bylaws and the law, it's done. There's nothing about receipts, it's nothing about payment. Everything that we voted for is gone. It's null because we violated the policy.
Yeah, that decision is null.
No, invoices, check, payment, all of that is null. It's gone because of that violation. According to Robert Rules 847. We can't break one rule and
Point of information, it's not a matter of bringing forward invoices or POs or it's illegal, it's against the bylaws. So we need to move forward on the policy.
this point of information, if someone else wants to, after we vote on all of this and start all over the proper way, they have a right, because that's your privilege.
To bring receipts.
No, to make that whole motion all over again, that person have a right to privilege, but it couldn't be the treasurer. But everything that was voted for
Is gone.
It's gone. The paying of the bills, the pay, all of that is gone. And that's gone because of that violation. We have to learn how to live by policy. It's gone. No more of our checks and none of that. If another board member wants to come along and make that motion after we kill this, it's gone. They have the right.
Sure, yeah, that's what I was going to.
Yeah, but right now, as a board, due diligence, and as a board, we have people waiting here to see how are we going to react as it relates to policy.
Right. Anyone else? Okay, so we're gonna vote on the motion. Does anyone need it to be repeated? Okay, so, yes.
So we're on the motion now, right?
Yep,
So we're going to the motion, we had discussion.
right.
So then I guess we do a vote.
Yeah. And we could have a motion repeated. If we could have a motion repeated.
Motion, trustee Bill motion that the board agrees to
No.
vote on all 17.
Point of information. I can repeat the motion.
Okay.
The motion on the floor is that the board is making a motion to agree that the vote and the decision that was made on August the 17th is illegal and voided, and we voided it out.
Okay. So we will vote, a yes vote indicates that it was an illegal vote.
Yes.
Board member Linda Booz,
Yes.
board member Laura McIntyre,
Yes.
board member Joyce Ellis McNeil,
Yes.
board member Gilbert,
No.
myself, yes.
Motion passed. What's the next?
Yeah, oh, I'm sorry, the motion passes, 4-1. And so, letter E, we're on, bylaws.
On the last part, others, haven't
Yeah, we're on bylaws, letter E,
Bylaws, yes.
and I don't know if anyone wants to talk about bylaws.
Yes, I recommended that we had put the bylaws on the agenda. It is required by MASB and the state, in order for us to start talking about making changes to our policies and bylaws, we must complete a board assessment. The board assessment allows MASB and trainers to come in and to help us make any changes we need. And they the one that helped us. I witnessed a board assessment that was done in Ben Harbor and a couple of districts in Muskegon. And oh my God, you can tell the board how you feel about them, and then you can change the bylaws. We cannot change bylaws at the table like been doing in the past. We have to have a board assessment, which is a SWOT analysis, our strength and our weakness, and then we come back we send that to MASB, and they come back and they will help us with our bylaws, rewrite them because there's some discrepancy in them, and they will help us get back on the right track. But they need the SWOT analysis to do it. They've been trying to get this done for the last 3 or 4 years, and that's why we're struggling with our bylaws. We don't do the board assessment. They have to be done yearly. Each board member has evaluation. If you're chairing a committee and it requires that you do an evaluation, it is your responsibility to make sure that each board get that form. So the board assessment, the executive secretary gave us, we completed. You can talk about things, you don't lie, but if this is to help us make policy changes, And then we go back and look at our bylaws and make those changes. But this is why I decided we have it, because our bylaws are not being followed. Human Resource Department has a requirement to give each board member the evaluation of the attorney. Attorneys are evaluated once a year. Those reports have to be turned in. Each board member has a right, including the attorney, have to do their evaluation as we make the decisions. So you have to have the evaluation. We as a board must move in the direction of policy. So I think HR has the evaluation, and Vice President, you have the responsibility to complete these assessment. I can drop it off with Mrs. Beard, and then she sends them off to MASB, as well as your evaluation from Trustee Gilbert. As we had copies of the evaluation, and you can get them. She can pull them off and send them to you. You evaluate your your attorney, and you get those back. And this is a privilege that all of us have. This is your voice right here, what I don't like and what I do like. And that's policy. Not that I'm making up. But we've been trying to get this done for the last 2 years so we can change. No, my goal, and I spoke with VP Chris Delmaroni, all of us came under some really difficult time. Policy, bylaws, and my goal is that the VP is responsible for this, is that we get everybody back on track, so that any other board member come, whether elected or appointed, they have a clear direction, and that's what this assessment does. And I suggest we take our time and do it and get it to them, so we have enough time, Chris Delmaroni, that we can get this done and it gets it back to you very quick, and then we can move forward and make those changes that you and I and other board members just totally need help with.
Pastor Gilbert, I see your hand up.
I would only say that certainly we should have done this 6 months ago.
Did you say years?
Yeah, obviously.
I said 6 years.
And regardless of where we are and how much trepidation we have caused ourselves, is that it's a good thing to look at yourself, examine yourself. And some of us have a tough time doing that sometimes, but it's something that's needed, irregardless of who is saying it at this table after November 8th. 2 of our colleagues will be here, maybe the rest of us are gone, but still the district has to move on. So if it is to benefit the district and benefit the movement of the district, then I don't have no problem with it. It just, we have to meet, we have to go ahead and do it and get it done. Superintendent has to be evaluated. Others have, the attorney has to be evaluated. I'm still sort of fogged in my mind, I guess. Who is our attorney? Cherise Lee, I thought was our attorney. Throom, are they our attorney? Are they one's the district, one's the board? We need to clear all that up in the process before we go into.
What is your point?
I would just, since he's speaking, the board attorney, we're the only district in Michigan has a board attorney. It's been advised on several occasions. We went through that with Kendall Wills, that they always end up in a conflict of interest. The district has some of the best firm that I have seen. Trump been around for 75 years, and Middle City. They the one that represent the district and the board. It is just doing a certain people who reign that sits in this seat. They are not here anymore. You guys replaced them. They brought in the board attorney for their own personal reasons. What I'm saying that We have a district attorney, notifies, don't come over your house, don't call you up, and you guys know we deal with Trump. They're gonna follow the policy to the T. And that's what we're looking for, a non-bias, and that's what Trump does, it represents the board, not individually. They move by the district, Middle City. Middle City represents the 3 board members, because we don't have to pay them a dime, each and one of us are bonded, so that we don't have to pay additional attorney fee to a board attorney when it's already paid for. Our bills are already paid. Anybody that do sue us, Middle City takes care of us. And so we don't have to pay. We're paying too much money. Board attorneys are an expense and a burden to the district. When you have Trump and whoever else they use as another one, for the lawsuit against the water crisis, ACLU, I want to say, we have attorneys for that. And I was just learning a lot becoming president. We don't, and you go to MSB, they warn us, we don't need a board attorney. That's why I use the district, because it's unbiased. They're gonna give their legal opinion. I don't see them no more. They don't come over my house. And that's the issue. And that's one of the reasons that board attorneys, all attorneys, Trump been 75 years, they have a 1-year contract. It is the policy. You cannot violate policy. You cannot give yourself a 3-year contract, even though we voted for Robert Rules Act 47, it goes against policy. But we want to straighten that out, Mr. Gilbert, because it's frustrating. Chris and I talk about this all the time. It's frustrating.
Okay.
Point
This is
of
one
order,
point.
point of order, still have the floor.
Oh, yes.
She gave a point of information.
It was long.
Yes, this is good.
Yes, it was. So, the only thing that I'm saying is that if we're going to do these evaluations, we've got to start with us. I don't think we should be evaluating anybody but us first, the board. And if that board assessment, when can we get that done? Can we work on that first? I'm just
The
asking.
point of information, you do this individually.
I know.
Okay, so we don't have a discussion about it, and so we just give this out. The next thing was, the 2 things have to go together now.
I'm just, hang on, I'm gonna.
Oh, he has a question, sorry.
Laura had her hand up. And you don't have to make, we're not gonna do plan of information.
Okay, thank you.
Recognize you.
Thank you.
Yeah, I just wanted to say, just for context, this is imperative that we make some changes. I absolutely agree with every board member, because back when we had the election in which Joyce and I were elected, there were 3 seats that had been vacated. And in the time that Joyce and I and another woman were elected in November, there was a lame duck session between November and January. So we were voted on, we assumed office, but we were not able to participate in the board meetings until the January meeting. And in the interim, between November and January, over 30 pages were changed and or added and amended to our bylaws in that lame duck period by former board members. So we have a lot of work to do. We have a responsibility and a duty to the public to rectify that situation. We were left with a mess on purpose that gave an unequal balance to the, it really put our board out of whack. It really did. And so let's move forward. Let's get some of this done. The other point that I wanted to make was that in terms of a board attorney, it is unprecedented to have a board attorney. You have vendors who are contracted according to specific legal situations. Like we have, True just doesn't do, everything. We have different branch. True is huge. So they do like property on the one hand, then you've got like, an ACLU thing. You have different legal firms who are working in their specialities. The problem when I assumed treasurer was that we had a board attorney, again, that had been put in by a proper changing of the bylaws that was billing the district over $1 million a year. And so that was one of the things as treasurer that I tried to call attention to and you know, get resolved. So hopefully we can get past that hurdle and move forward as a district. Thank you.
Board Member Williams.
Okay, regarding this board assessment, when is it due? Is there a deadline to turn it in? Because we don't want to be hanging on to stuff for a period of time.
First sentence, Wednesday, or no later than the last Wednesday in May of each year. So it's fair to say we're behind.
However, MASB said they understand that we're behind, and we can get it to them as soon as possible. And we just get the information over, I can complete that as I'm sitting at home, drop it off at Pam. Place the same with the evaluation, you can do them both at the same time. Get the form, get them in. Our executive administration can forward Cherie's lead her evaluation, because the board, the attorney have to do their own evaluation as well. And we get all that information in, and then we send it to MASB. So they know that we're behind. We're behind in our superintendent evaluation. We need to do that ASAP, finish up where we stopped at. So I would like, I know you want to speak, I would like us as a board to have everything in order and put the goals in the direction for, we're supposed to have that done. So when other members of hope, you know, we don't know who it is, when we come back in September, when we come back, we'll have the goals in the direction, we have it's by law, we have to do the superintendent evaluation. We can get all of this done and have our agenda set and be gone, but we're behind, but they did say that they would, you know, just get it in.
So the last time this was revised was August 6th, 2003.
That is the same, form that they're using.
Okay. So
That's the
it
same.
hasn't been revised since then.
It's the same form that they're using. And it's a big one to get the information back. I never seen it completed. It's really intensive, that you can really see how you're performing, how you feel about your board and all of that. That's where that changes take place there. So like Chris was saying, we're going to have to have some meetings and get some stuff done, because that's under his leadership.
So, Pastor Gill.
I just have one question. So, the only attorney that we should be evaluating is the board.
Is your board attorney. And,
Who some say it's unique that we have it. Is that right?
Not just some NASB, you know.
Yeah.
It's unprecedented.
Where you going on Saturday?
I just,
It's
there
so,
is, if I may, if there is, if the contract is up and we need to decide whether to continue the contract or not. We did do it, I guess, when we were supposed to, and we should have. We would have not been in such a quagmire, I don't know. But if we got to do this, and we need to have meetings, and we need to come and do the work.
yes, we do. And under your leadership, Pastor Gilbert, that contract, as you review that contract, our role for the subcommittees and meetings is that we line up everything with policy. So all legal contracts.
Trustee, I agree with you.
Yeah, and so then we have to go back and say, okay, this is a 3-year, and then we have to amend that to 1 year. And we don't even have to take a vote, because it's void because of this 1 year. So we can get all of this stuff done and make these decisions move forward. But I'm gonna get mine done in Eric. Today is Tuesday, before the end of the week.
So, Do we send them in to Ms. Pam, or do?
Ms. Pam gets it, and then she gets instruction what to do.
So let me chime in here. We do need to do a board self-assessment. It's an assessment of ourselves as our position comes up, and it's assessment of the other board members.
Well, the assessment is these questionnaires. So they talk about our policy, academic, finance, all of this as it relates to the board. What kind of support you need, board superintendent, all of this. So you're grading this, you're grading it. And you send it back to them, and they'll show us where our weakness and strength is, something like a SWOT analysis. And it's also talk about us, and you get to talk about it, your president, just, you get deep dive.
Yeah, there's a president in here.
They did.
Evaluating and others, but, so that all being said, this needs to be done, but at the same time, this should not, in my opinion, this should not hold up bylaw changes. Because, I mean, if there's something wrong with our bylaws, we can make a change. We don't have to do a board assessment every time we want to make a bylaw change. And I would
If you
think,
go to your policy book, and your board policy, as it speaks to bylaws and policy changes, if we did make a change, well, first we have to know where everybody got to be agreed where your weakness and strength at. And then your superintendent have to be involved in it as well, because the superintendent plays a big role in this as well. It's over in your policy book and in your Neola book. And then if you do make a change to your bylaw, it has to stand for 30 days. It doesn't change right away. You have to let it stand for 30 days. That's over in your Neola policy. That's related to bylaws and policy changes. And you have to do those changes with experts in front of us, which would be your MASB attorneys. They would come in and Neola, because we have to make sure that the board follows. Well, we are the only district in Michigan have a board policy. No other district have it. They follow Neola. That way they don't get in trouble. But because our board policy is all over the place, that's why you can request that, or you can vote and say, do not use board policy, that's follow Neola. And then we'll be in line with policy. So those are where we at right now. Your bylaws is the same way. They would come in and look at our bylaws. And if you look at those bylaws, something ain't right in those bylaws that keeps us at par with each other. The one that remove a president without cause will put in our previous board member to get rid of a certain board member, and they didn't change it back, and it just lingered there. We want to make our bylaws the law and have a sealed copy put away somewhere where we can go back and say, did somebody go and sneak and change this bylaw? And so that is why our bylaws is out of order. But it would take, I spoke with MASB when I was in training, and Neola, they would love to come back because they see that this district right here, it shows you how dysfunctional it was in Muskegon. We need help. We need help in helping us put this together. I don't want to sit between 6 or 7 board members changing bylaws. I want to hear from the expert why we're what we're and why we're doing what we're doing. But we just can't just change the bylaw without expert, and then it takes 30 days for it to even get passed.
just a point of information. These are our bylaws. And we should be able to deal with our bylaws as to what we want. Neola and everyone else, they don't know what we need as a district, as a board in our bylaws. Our bylaws don't even say the name of our organization.
That is because you have, Laura just explained what happened. They had the original bylaws. We have. What I'm saying is they're supporting just one person. If I'm going to talk about changing bylaws, and we know we want you, that has something to do with what we want to do, we just want to make sure that they are in order, in the proper place, and we're just not all over the place. I had one person, well, I'm gonna change this bylaw because I'm mad at you. We don't want that anymore. We want an expert here to explain to us about changing our bylaws and writing bylaws. As a board member, that's what I would like to see. I don't want to see 5 or 6 of us beating at each other, and I want this and I want that. We need an expert here to help us with that, if that's okay. We're not saying that, we know it's our, but we need expert, not my opinion.
Well,
But that's something the board has to go in and understand.
all right, so let me say this. I mean, you know, on day one, I was misled. I was given this, and I was told that the bylaws and the bylaws and the, what are we talking about? That's true. Bylaws and, what's the other thing? We just got, and I think the bylaws and policy were contained within here. Now, some 11 months later, I received policy. So I guess policy is not in here. So,
Point of information,
uh,
when I was elected and first time onto the board, do you know what I was given? Nothing. Nothing. So, as an elected official and appointed official, you assume the responsibilities, it is your duty to find out the information. Nobody has to give you anything.
oh, but they do.
Who?
I think it's the vice president. So,
So that's precisely our dilemma, Chris. Precisely the dilemma. We have these board bylaws and policies changed and put our district in confusion and turmoil. We're trying to get it back into order so that we have, like, when you come onto the board, you're given the information you need and the tools to be successful.
they're talking about that day one. I don't remember. Point of information. I'm talking about from day one. I brought it up at GISD as a representative over there. Got nothing with the organization, what they do, what their policies, their mission statement is, what their budget, nothing. Got nothing. So they're coming around and they're just giving a little bit about that. But it's like top secret stuff.
We have the power to change that, board member. And I'm just giving you an example, removing our false administrator. You know how that was put in there? Because our previous board member, Daniel Green, saw some things that was not right, spoke up against them, and what they went against her, we was always GISD, spite me here, I took money, I don't have to take money, I got money. But, she made us, she found something, and they went after her, and to get rid of her, they looked false in her. And to make sure that that person, now this is on treasury, and we so we want these bylaws to line up with them. And that is why we're gonna talk about bylaws, and doing the board assessment, that has nothing to do with that. And then you, as the vice president, you call MASB and say that they can come out, and we have that discussion. I'm 100% with you. And we've been here 2 years, and you guys have the good stuff. Y'all got the good stuff.
We got this.
Zero.
Thank you, Vice President. I feel like that we did the short of the stick, there's no question about that. We got the short of the stick when we came on board. It seems like that when things were brought up, it wasn't really considered for whatever reason. I certainly wouldn't blame our colleagues for that, because if they got it worse than we did, and they probably did. But the one thing I do know is that whoever sits in these seats going forward, it should be better for them than what it was for us. And the fact that we didn't get any initiation, I don't disagree with having the fortitude of the oath that you took and doing all you can to go and get the information. We both did that, Vice President. We both did that. We tried to talk to our former board assistant to the board, and this is all that we got. And somebody else one of our trustees had won this thing. And then the president now, she had won that thing. I never did receive one that thing. And all I'm saying is, it just comes a time when you wonder if we're really sincere about making those that are responsible for that kind of thing do their job. Well, this is some of my angst that I had about that we need to deal with the bylaws. I talked to those up there in the speaker about Neola as well. Neola, Trustee McNeil, you're absolutely correct. They follow the law, no question about it. So we can all agree to that now. And MASB, they follow the law. So the question becomes, if they're going to come and help us and do the very best for the district, we have to find a way to take ourselves out of it. And I totally agree with that. There's not going to be any kick for me whatsoever. But we got to be able to get through it. And I think we can, because we should. Because it'll help the district go forward, and to move forward, we got critical things. I'll say this, and so I don't have to make any further remarks. It's difficult. How can you rise as a district when you got all of this stuff that is out of order? And I do believe that some of this is because that we can't quite get our act together as board members toward one another, because a lot of stuff is chaotic. But it's not anybody's fault at this table. And the things that we would have tried to get fixed, they just wasn't fixed. Somebody is involved. I just don't know who. But I did take a hold. So I had to put the fault on me. I'm at fault. So let's do it. Let's get it back to whoever we got to get it back to. Let's get MASB back in here and Neola or whoever. And let's do it. That's one thing we can do.
Thank you, Pastor Gilbert.
That's okay. I just want to say this to our board member. Despite all of this we have going through, let's give ourselves an applause. We've had a strategic plan. We went and meet as we did all our community forum. On the Christmas year, we listened to them. We did the children wanted new food. We got that done. We got an emergency deficit order. We did that. We got our band, got new uniform. We did that. We had some good programs that academic need. If you think of, you should be able to think of 10 great things that we have done as a board, in spite our regular policy on. We have come a long way. We have done great things. We are now in the process of trying to move payroll out of property to halfway of these rates, $6.50 an hour. We have been working. We've passed the teachers union agreement. We've been working with administration. We had got 13 buildings that we all voted on to sell that kind of went through. We also have received the proposal to do the grant. We have done a lot. Let's not shortchange ourselves here. We have done a lot, especially on the community relations. built relationship through those forums. They still talk about those. The graduation, the students still talk about how we showed up. And that morning, early in the morning, they still speak on that. We have went to a lot of school programs and stuff. So we got Go Rider, and we did this, the board, we voted. We did this in spite of. But do not give the media that leverage of saying we have not accomplished none. In spite of all of that, I treated you guys as a board, and when you appointed you, but you had equal rights. And you made a decision based on policy. And so now we're going back to policy and getting this stuff straightened out. But we have done a great job. We just have to learn how to respect each other and move forward. Don't take away what we haven't done. We haven't done. You should have waited till the teachers open house. Mr. Jones named out over 30 or 40 days. We even have a community partnership agreement. The first time that the board said we're going to allow community partners to come into this district and help us bring our kids back. And so we either pat ourselves on the back because the media is not going to do it.
Okay, that means, I'm going to move to letter F, which is other, and I'm going to ask that a motion be made that we move the proposal of the administration to not foundation, for them to look at that, and at the same time ask that Central and Whittier return.
Can you repeat that? Because the noise.
Sure. So I would accept the motion or make one myself. I think I can do that. No. Okay. No. I'll ask the chair will accept the motion to move the grant proposal from the superintendent, the administration, to my foundation for their consideration, and at the same time ask that they help us in tearing down the Central and Whittier campus, which is more than just those two buildings, but there's a welding house in the back and there's a swimming pool.
So,
Those are two separate motions.
Well, he was moving, he wasn't making the motion because he couldn't make the motion.
We would accept. And
so I just, when he finished, I said, so moving, that's all. If you don't get a second, then that's fine.
yeah, I mean, if we want to break them apart, we can do that. But this doesn't commit us to anything. It simply has, it's like asking for grant money. So, what you want?
Mr. Johnson called us a proposal plan.
Yeah.
That is not, and the board have to look at that proposal plan. Also, I sent you guys the, I remember how the MOU of what they're looking for once we look at the proposal plan. The board needs to look at that proposal, look at it, and critique it, see what it is you want. And also the letter that Ridgeway sent to Danielle Green was March the 13th or something. And we need to know, is these the same requirement that you're looking for? If I give you this 200 million, this is what I want. So we need to get some updated information. I believe that you was one of the person that went to meet Ridgeway and to speak on behalf of the board. The board had voted that and agreed that this be a board and not one person come in there going, I didn't tell them that. We would just like for them to come before the board and we can have a little workshop discussion, say what it is that you want, what we really get. But we have not read the proposal. It's not even a great proposal, it's just a proposal plan as it relates to the strategic plan. If it makes sense, and then they come with us, but we're not gonna just go over there and we just tear this down and do that. We have to be due diligent and work collectively as a board.
So, with all due respect, we're trying to follow policy, we're trying to follow very disingenuous to put something other, but there's no agenda item. It's a surprise. One of the rules of the NASB is there should be no surprises. This wasn't on the agenda. It's already after, it's 9:13. This is a huge discussion. This is huge. So respectfully, I request that we table this. It's time to go. The meeting is over. We need to put it on an actual agenda item, and it has to be something that we can prepare for and discuss respectfully. This is an issue.
Point of order. First of all, there was a second to this, so, you guys for like a second, so, we're spinning our wheels if we don't want to talk about it, and it can be brought up another time, and whatever meeting that is, or it can be committed to the president, or superintendent, or whatever, but those are the things that I think that we should be able to do. We should be able to deal with these things as a board, no matter how much information that we have, and we want more information, we should ask for. It's just that simple. But I think we do the superintendent a disservice, because in my mind, we need to move forward with our community partners, Mark or Elon Musk. I don't care who it is. If they have money, they need to know where we're coming from, and they're probably waiting until the election to know where we're at. They got that right. They got the right to do that. But we still should be moving forward. We don't want to lose the community partners, and they go off, and we got nobody to deal with, because we don't have no $100 million sitting somewhere.
I think we're doing Mr. Jones a disservice. Mr. Johnson had this board has opened heart and everything that he has asked. He gave us that proposal. He never came back, or because right now he's called for trying to get his evaluation done. The board as a whole has always agreed that we want to tear down Central. We got to agree that we work with community partners. That is not the issue. The issue is that we have to have all of this stuff looked at, and we have to send it to our district attorney and let them look at those proposals, those requirements. It has never been an issue, and that's what we was moving forward when I was president, waiting on him to make that decision. But we had so many interruptions that we had to get hard on. We had to hurry and do some movement. School was starting. We still have time for that, but it just has to be done in decent order. And you have to have an attorney, district attorney, to look. But we didn't look at the proposal. We don't even know. I know what the one that said for 13 when he wanted, that letter dated March the 13th. To me, it's okay. I will make a couple of changes. You know, Dr. Rice came. Excuse me, just a minute. Dr. Rice came. Okay.
Chair, I'd like to ask Trustee McGill, did you read the proposal that the superintendent?
Oh, yes, I did. I read the proposal.
Can I ask you just one question? What is the problem?
That's something that we can discuss with the board. It's not a problem with it. It's an issue with it.
It's not a point of information.
It's not a problem with the
Yes, it is.
It's a point of information. He asked me a question. Yes.
He asked her a question.
It was okay. I thought Chris said that we would have to open dialogue. Yeah. He really didn't have to say point of information. But, Trustee Gilbert, I have read it. I have looked at the letter requirement, what we would have to do to get it. However, I still will say that there's more discussions to be done with it. It does kind of line up with the strategic plan, but we need to continue kind of. But there's some other things that we as a board as a whole need to make their own decision about what's what. I would like to see it get done. I've been trying to get a shovel in the ground for the longest. However, there's some other issues that we need to talk about. I looked at the letter that was sent in March 13th. So we want to make sure that we are on the same page. It was my job as president to say, oh yeah, I'm going to go here, you're going to do this here, come back. I want the whole board to look at it, review it, have a discussion about it. Because what I might have a problem with might not be a problem at all. That's not the issue. The issue is the whole board needs to look at it as a group, and this is something Chris Deveron, we might have to do in a special meeting by ourselves, where if there anything on the agenda, bring our partners in with respect and let them speak with us.
Okay, so that all being said, this was simply not committing us to anything. It was simply to start the discussion. It's kind of like turning in a proposal for a grant, and those who are asking for the grant say, well, we can do it, but, you know, we're not putting money towards that project. We're going to stick over here. And then it would be up to us to decide if that's where we want to be or not. So this is only about starting the discussion. Yeah, I think we want to keep it until the new word comes on as far as any building. But tearing down, that can happen anytime because it has to happen. So, you know, maybe if we break it out into two separate motions or only about the tearing down, I don't know what it.
We don't have a commitment from it. We have what you said. We don't have a commitment. We have, I don't know what Mr. Johnson's telling you guys, but when I was working with him, we never had a commitment to do anything but get these schools renovated, get some other things done. What I was telling you is that, yes, but we just kind of said, well, I'll make a motion and give him, and he will tear center down, and we don't know what's the requirement in all of it. We don't know, we don't have enough information. Yes, but they need to be torn down, but there needs to be more discussion. And we could just have we agreed at the last meeting. We would have a workshop, put something together, where we as a board as a whole, and put that on the agenda. It's not going to be 2 hours tomorrow. It takes 2.5 years to build a brand new school, and there's some legal issues that have to be done, and we as a board must have clarity and understanding. And I don't know what Mr. Jones is saying, but I'm understanding that we're working together as a team.
Go ahead.
Okay, can we table this motion that you made until we have further discussion with the superintendent? Okay.
So we'll let go of that, and I'm all trying to move forward, stuff forward. We have to deal with the issues. We haven't dealt with them in a year. Central Hood hasn't been dealt with in over a decade. You know, and it's been thrown on our back. Washington.
We were dealing with the financial subcommittee for the whole meetings. We were dealing with that too much. We were actively sitting at the table, discussing these things, how to shuffle things around with schools closed. So it's not.
Yeah, what I'm saying is Central is closed. Central is dead. Okay, there are no more Indians being graduated from Central. Okay?
I understand that.
So, what are we going to do? How long are we going to sit on this?
It's not just sitting on, we're saying that we move this for public discussion, have a meeting where we can sit down and go through this stuff, because it's more to me tonight than what you're saying. It's more to this project, and what you're talking about, but the board and Mr. Jones and all of us have to sit down and have that discussion on the agenda and make that talk about school. We all agree to that. But not to make a motion about, and we don't even have the money, we don't even, we don't even have a treasurer, we don't have any. So I just think that we need to just table this. It's 9:20. We agreed that it'd be 9 o'clock, a little after 9. This other issue was something that's a big agenda issue, and that if you want to send out a vice president send out an invite, when we're going to have the next meeting.
All right, what do we decide on the meeting? Can we decide on the meeting tonight? Go on.
This is, I think, very disrespectful to the staff. We agreed and we already brought up 2 other agenda items after 9 o'clock. So with respect to everyone's time, respectfully request the adjourn.
We have to be here tomorrow.
Yeah, we gotta be.
We have to be here tomorrow
We have 2 meetings tomorrow.
to prepare for it.
Okay, that's you.
Chairman, Gilman, don't have a move for adjournment.
Yeah. So, the board is for adjournment. All those in favor?
Aye.
Those opposed? Nay? It's unanimous, 5-0.